So George said, the probation. Sure.
All right. We're down. Sanders.
Now we don't have any of them say probation, you know.
Oh, I see. I'm sorry. Promise I didn't disconnect. Not.
Minutes.
Yeah, whatever. Right here. Well, all right. I'll do it.
All right, here's the. Okay. Am I coming through okay? To the microphone?
Yes.
Okay, perfect. All right, so number 113 SC 120263, Quantavious Jamone Bailey, Ms. Carter.
Yes, Your Honor. Mr. Bailey's here on a violation for picking up new charges in 24 PI 008075. The offer from probation today was 2 years to revoke. We are stipulating to the violation. However, we'd like to ask the court for less than 12 months on the revocation, and also to give Mr. Bailey credit for the time that he's been here for the past 90 days.
All right. Mr. Jenkins.
Judge, how are you?
Doing well. Good to
I
see you.
understand that there is a stipulation between the parties. Am I correct on that?
Right.
So, I don't believe there's anything, the violation has been, the parties have agreed.
No. Your Honor, counsel is asking for 12 months, probation is asking to revoke 2 years
Oh,
and reinstate the balance. The defendant has 6 new felony charges. He's on probation for 3 active probation cases. One is a suspended sentence, and we're not asking for that suspended time. The defendant has a new charge of robbery, 3 counts of assault, possession of firearm, by convicted felon, possession of firearm, during the commission to attempt to move out. The violation for today is the new charges, Your Honor, and failing to submit to violation and testing for he failed to complete a mental health evaluation after being instructed to do so July 31st last year by Supervisor Whitrat, and on 8/24 and 9/24 by Supervisor Officer Burke, and on again September 6th, 24 by a different probation officer. So there have been multiple times to get the defendant to test for the mental health evaluation, and he failed to comply with the recommendations of probation. He had a revocation hearing just last year before those attempts, which failing to get evaluation is a violation of their revocation order. May 16, 24, he was ordered to must be assigned a mental health probation officer for tests. He was ordered to be tested at least 6 months until stable on meds. And that time there was another violation of probation for that revocation out of Cobb County, which resulted in the conviction. And probation is asking to revoke 2 years, Your Honor.
so if the court is specific, we're not asking for you to move forward in connection with the new offenses, because obviously we don't have any limits. But the technical violations in connection with this defendant, while that period, I believe that 2 years is sufficient for technical violations, Your Honor. And so we would like you to, in your discretion, revoke 2 years for the technical violations that are alleged before this honorable court. And we'll leave the rest of your discretion, Your Honor.
Looks like you've got 2 years and reinstate the balance.
Yes, on all three cases, I would state those, 13 SC 120263, 13 SC 120273, 13 SC 120682. He has a total of 7 years, 11 months, 29 days remaining on all three cases, Your Honor. And the defendant has been in custody for 2 months, 29 days.
Then you're no problem with giving him credit for his time he's been in?
I can't consider credit to, state order, the credit can only be determined by the custodian. And I can put that notation on the revocation order.
I mean, I don't have a problem giving him credit for his time. He's been in almost 90 days.
Yes, Your Honor.
Okay. All right. So we'll do that. Revoke 2 years, reinstate the balance. And if they decide he can get credit for the 2 years and 2 days, you said? 2 months and 2 days?
2 months, 29 days.
29 days. Okay. 2 months and 29 days for credit for time served if they will let him do that. All right. Best of luck to you, sir.
Yes, ma'am.
Tory Knight. All right, so we got position 220 SC 175401, Victoria Shanice Knight. And you'll be handling this, Ms. Carter?
Yes, Your Honor.
Okay. All right, go ahead.
Judge, Ms. Brown, if you would, you highlight for the court at this time the performance of this defendant in connection with his probationary sentence and what, if any, technical violations exist.
Okay, Your Honor, there was a particular concern, labeling additional violations for the new offense. This case was reset from, December's 12th. For the, I believe, for the defendant to be granted a bond on the new charges. And we're before the report again today. The defendant has a new violation for the law. Supervisor Lee was arrested by the East Point Police Department on about 10/31/24 for committing a new offense of battery, assault, and criminal damage to property, possession of firearm, commission or attempts to commit certain crimes. On January 21st, 24, County, Georgia. I'm sorry, January 21st, 24 in Fulton County, Georgia. Supervisee continues in Fulton County Jail. You state that she was granted a bond of $31,000. Second violation is avoid injuries and vicious habits. Has been testified for THC 35 times. amphetamines one time, episode, and alcohol once. There's failure to submit to evaluation and testing related to rehabilitation and programming. The defendant missed 5 mandatory drug screenings in June, July 4, September 1, and November 3, December 3, January 2. The missed evaluations date back from 2022 to 2023. There are multiple missed drug testings. Complete a residential or non-residential program for substance abuse, and the defendant has failed to complete the MADRC. And she was removed from the program due to excessive absences in 2023. And had completed one class since 2022 enrollment. And supervisee has completed 60 out of 80 hours of community service. And last reported 8/2/2023. And that concludes the violations, Your Honor. Probation's asking to revoke 1 year to serve day for day, reinstate the balance, and active probation for 2 years due to the defendant's ability qualifications for State Bill 174 unsupervised probation. That's the right.
All right.
We are stipulating to the violations, Your Honor. However, we will request time served. She has been in 93 days here in Fulton County Jail. However, she's been incarcerated since February 2nd of 2024. So just under a year, she's been incarcerated in another county. She was transferred here from another county, I believe. She went from, was it Douglasville you came from? She came from Douglasville. So that's part of the reason that we're asking for the time served. She does have a 1-year-old son that she is taking care of. Currently, her son is with her mother. She does have, since she's been on probation, she was able to enroll in some courses to get her CDL. She has finished those courses. However, she's just waiting to finish the final test to get her license. So we're hoping that's forthcoming so that she's able to be employed once she is. Nothing further, Your Honor.
Mr. Jenkins? Well, yeah, and then, or whomever.
I apologize, Your Honor.
Probation, you had something else, or?
That's right. Probation take new firearm charges very seriously. And the defendant is on probation for a firearm charge. And there's alleged new firearm charge.
All right. All right, anything else, Mr. Jenkins?
Not from the state, Your Honor. We submit that you take the Department of Corrections recommendation and judge accordingly. Thank you.
All right. All right, we'll take the Department of Probation's recommendation, revoke 1 year day for day, reinstate the balance and active probation for 2 years due to SB 147.
Can she get any credit for the time that she's been here in Fulton County for the 93 days, Your Honor?
Your Honor, we have no objection to that.
Okay, yes. On here it says 2 months and 28 days, but yeah, whatever the number is, she can.
I need that. And as of both the county records,
Yeah, for,
only shows 10/31/24.
My W case right concur with
when she was booked into Fulton.
when I got.
Oh, you said she was in February in other places and then came here.
And then my request to the court was that you weren't going to give her credit for that. However, you were going to give her credit for the time that she's been here in Fulton.
Right, and that she, I don't think she heard that part, that the
Oh,
other ones, yeah.
Oh,
Yeah, so the time she's been in Fulton. Thank you, ma'am.
Isaiah Burke.
Oh, I know. I got you.
Quintavious Bailey,
Isaiah Burke, position 7.
what's that? Oh, what about Quintavious Bailey? Oh, we already did that one, yeah, sorry. Oh, okay, all of them at the same time, all right. Isaiah Burke, 23 SC 187063.
And also position 10.
Oh, Yep, and position 10. They got you all over the place, don't they, right now, Mr. Jenkins?
You know,
I'm all person and I haven't seen you on Monday before.
Oh, okay. Right. So you're Mr. Isaiah Burke?
Yes, ma'am.
Okay. All right.
For the arrest warrant state violate the criminal law of any government's doing it, you can have a new charge. In special condition, violation of no firearms, have alcohol during, alcohol, drug evaluation and treatment. On, July 7th, 2024, the defendant committed to new count of purchase, possession, or, have controlled substances in Schedule 1, or narcotics in Schedule 2, felony, receipt, possession, or transport of firearm by convicted felon, or first offender felony, first offender felony, tampering with evidence, which is a misdemeanor, and Stevenson, Georgia. The defendant's, special conditions, state that the defendant should forfeit all firearms, forfeit all weapons, excuse me, and have no firearms, and the defendant, was arrested or was found to be in possession allegedly of a firearm and narcotics. The defendant is asking to revoke 6 months, day for day, and reinstate the balance.
All right.
Judge, thank you. At this time, we would submit that you take the recommendation of technical violations stated by the Department of Corrections and sentence the defendant accordingly. For any credit that he has been in Fulton County, he will, we have no objection for him to grant it. And that's our decision at this time.
All right. Ms. Carter?
Your Honor, we're asking for time served on behalf of Mr. Isaiah Burt. He's been incarcerated since July 7th of 2024 in Stevens County. He has since been transferred here. He's been here in Fulton County for 30 days. With that said, and talking to him about the Stevens County case, that case is still open and pending. It's a situation where Mr. Burt was in a vehicle with other people, and everybody in that vehicle got charged with what was in that car. So I do think he will have some defenses should that case go to trial. Again, Mr. Burt is working in construction. He does rebar work, so he will be employed upon his release. He has 2 children, 19 and 14. His 19-year-old son is off to college next year, so he'd like to be there for that, getting him prepared. Nothing further at this time.
All right. So you want to credit for the whole time and not just what's in Fulton County?
The whole time. I want the Stevens County, I'd like for Mr. Stevens to be released today, Your Honors. That's what we are asking for.
Probation?
Mr. Burt, what did I say?
Yeah.
Sorry, Mr. Burt.
What's the state's position or probation's?
I prefer to be there.
Well, Judge, at this time, I believe that the time he should be accredited will be the one in connection with the time he's spent here in Fulton County. So we will agree to credit him per the Constitution, 30 days. His time spent in Stevens is out our jurisdiction, our control, and therefore on this case and on the charges that are before us here today that originate in Fulton County, she credited 30 days, Judge.
All right. I'll follow the recommendation of the probation and reinstate, give him credit for his time that he served in Fulton County. And right now I've got like a month and 9 days, so should be a little over that. Okay. Thank you, sir. All right. Now who?
You have a revocation?
Was it, you want my recommendation?
Yes. I just gave him credit for the time in Fulton. Atmore.
Yeah, but the client refuses to speak to me, so I don't know what's gonna happen when he comes out.
Oh, okay,
It's gonna
we'll
be-
just have a good time.
Yeah, it's gonna be interesting.
Beth Goldstein.
Pleasure, George State, pleasure. Nice to meet you. You're on the spur of the moment, so yes. Probably
Like it went offline again. Ms. Curtis? Ms. Curtis, can you hear?
Yes, I can hear you.
Ms.
Can you
Curtis,
hear
you
me?
gotta turn your camera on. I don't speak to a black square with a name.
Sorry, 1 second. Yes, I'm here.
All right. Ms. Curtis, say something, see if we can hear you.
Hello, hello, hello. Testing 1, 2, 3.
Can't hear you. You must not be connected. Yeah. Yeah, I can't hear you.
Give me 1 second. Hello, hello,
Yeah, she
hello.
can't, we're not gonna be able to hear her.
I don't know how to make it work. It says that my microphone is on.
I can approach with the email, or we can ask her whether or not this is what she wrote.
Yeah.
I'd like it back.
Email from whom? Oh, let me see. Yeah, you can bring it up. I'll look at it real quick. I'm not real sure what's happening with the podium. I think Mr. Norman Burke. I think Mr. Norman Burke.
I think I did.
Let's see. So for the record, Ms. Sanders, this is an email from Sade Curtis, SADESYMONE at yahoo.com to Mr. Norman. It was sent on 1/31/2025. Looks like it was forwarded to him. To whom it may concern, this document affidavit is to verify the truth of the police report at hand. My name is Sade Curtis. Upon the release of Deshaun Atmore Meta, there were no issues. The contact described in the police report is not physical, violent, nor was I or my child in harm's way. The argument report is an argument overheard by a neighbor who then called the police for a noise complaint. Police were not called due to acts of violence. Mr. Atmore did not pull a knife on me, nor was there any physical exchange. The police report was filed due to Mr. Atmore opening a CPS case. Once the CPS case started, Sade Curtis was instructed by the caseworker that if I wanted to remain in primary custody of the parent, there needed to be a police report on file in regard to the incident or complaint where Mr. Atmore be deemed unfit. Police report was filed after once the caseworker told me it was needed for my case to be dismissed. Mr. Atmore and I have chosen to co-parent for the betterment of our child. Anytime spent away is detrimental to the upbringing of our daughter. He's loved by his daughter and family. Best, Sade Curtis. That's the end of the email. That's not her under. Oh.
Hello? Are you able to hear me?
You want to email that to Miss Sanders? As a, yeah.
Okay.
All right, it's admitted. All right, so Madam Probation Officer, anything? So I'll just tell you this, sir. There's a couple things I found wrong. One, that she went a couple days later so that you would be denied custody of this poor child who in the middle is the victim. And it's bothersome that DFACS in New York or whomever it was told her, go make a police report so that we can do this. So either one, and didn't say anything about a neighbor calling. She went because obviously there's no police report of a domestic disturbance with a phone call, right? Is there, Madam Probation Officer, you know about? All right, so she goes down, does this, probably so she can manipulate the system and have him with the child. But one, I'm looking at your conditions of probation. It's right there in bold for the violent contact with the victim, and it tells you that you can't travel.
I'm pretty familiar with these people at probation, and they go over all the other special conditions. So you knew you couldn't travel. And it honestly would have been as simple as you saying, hey, it's around the holidays, or it's my daughter's birthday, or what have you. Can I travel? And they would say, yeah, most likely. So I don't know. I mean, like I said, she can't speak, and it's good or whatever that you guys worked it out. But guess what? If that's what she's going to do, and she's going to report you and have you arrested just to do that, she's right there using the manipulation. You by that child. So I'm going to go ahead and follow the recommendation of the state. And he has been in.
Making a determination.
I mean, here's the thing I'll tell you, Miss Curtis.
How
So
is it you can't
I'm not gonna be
hear
able to
me?
hear
Can you hear me, Your Honor?
Here's the thing. I'm going to swear you in. I'm going to ask you these questions, and
Okay.
lying to this court could get you in a whole bunch of trouble.
Okay.
Not just here, but up in New York with the child services or DFACS up there. So they'll find out that you lied, and then they may take you. I don't know, but it's going to get you in more trouble than you really want. All right. So I'm going to tell you, you got the right to remain silent, because anything you say would be used against you and can be in a court of law. All right. So give me a thumbs up or a thumbs down if you still want to testify. You got to turn your camera on. Still got to turn that camera on. Still got to turn the camera on. Ms. Curtis, if you don't turn the camera on, I will take that as you do not want to testify. Looks like she's not turned on. Maybe it. So, yeah, she obviously, Ms. Curtis, turn your camera on. All right, she doesn't want to testify. So give him credit for, says 1 month and 9 days, but however long he's been in custody in Fulton County. Yeah. I mean, she was sitting there on the video shaking her head, and then she just turned her camera off. I don't know if Mr. Norman wants you to speak.
You would like to address the court.
All right, so you discussed it with your lawyer. I know it may be against his advice, but you're choosing to speak on your behalf and ignoring Mr. Norman's advice. All right, go ahead.
Hello, Your Honor. Are you
What
able
did
to
you
hear?
want to say? I still can't hear.
Hello? Hello,
I
hello.
see she's saying hello, but guess what? We
Oh.
don't have audio because that podium's not working. So say what you want to say.
My phone just died as I was being
Okay.
sworn, so I don't know where I pick up from there. Hello? Can you hear me, Judge? Can you hear me?
But like I said, obviously, some people call it violence if you're screaming at one another. So let's just say they were screaming at one another and a neighbor called, and instead the other happened. I think all that's violence.
I don't know what I'm being asked.
How long do you need to take a? Yeah, I mean. You want to just pause for like 5 minutes? Let 'em fix that? Yeah. All right, so, we have, so they can hear me. No, on here. Yeah, yeah, but, all right, so we're gonna, everybody on here, we gotta leave Zoom completely. Okay. All right, go ahead. We're gonna, stand down for just a second. No, you can't type your responses, ma'am. We're gonna stay on for just a second, let him do something to the podium, get it back up and running.
Okay.
But I'll tell you, Mr. Norman,
This is the first revocation, like a month after you was on probation. That's important to consider something less than a full revocation. You're gonna be a period employee. There wasn't a lot of contact. You admitted his mistake and he's ready to correct it.
so his charges were ag assault, criminal damage to property, battery against the female who's pregnant, obstructing a 911 call. Those were the original one. So she lives up in New York. So how are you gonna see the baby? Because you can't travel.
Because there's CPS case now.
Yeah.
He's only gonna be able to see the child as
One at a time for the day.
he's only gonna be able to see the child as CPS allows, whatever they do that. He
And
has no reason to see the child.
all right, so we got 2 years, 11 months, and 5 days as of 4, so it's a little less than that now.
He did be 586 days.
Right, what says the probation? Anything else? And you still gotta do your family violence intervention program and your anger management that you haven't done. So we'll revoke, I'll revoke 1 year right now, day for day.
But it's 40 days.
Yeah. Credit for his time in Fulton County. Ms. Curtis, I know you can hear me, but stop lying on people. All right, next. Antonio Evans. Ms. Norma, you gonna email Ms. Sanders that? Okay, thank you. That's Antonio Evans.
Just to be safe.
Okay, you're gonna work to get that. Antonio Evans. Position 6.
Right, so it's 19 SC 16754 Antonio Lindell Evans. All right. Probation, you want to go first?
There's not gonna be any audio. Testing 1, 2. Can people hear me over Zoom? Testing 1, 2. Can you hear me?
Yes.
Yes. Okay. So I need to invite the podium back.
I'll sort out the podium, but you shouldn't need it going forward. This was just to make sure if anything happens with the podium, you're not kicked off.
All right, so then we need to unmute the other microphones, right? Because we're not going to be able to hear them.
No, you can hear them.
No. If Mr. Norman talks right now, his,
All the mics are coming to your computer.
oh,
and
coming here now? Okay, gotcha. All right, gotcha.
So we won't be able to have a video on the podium.
I'm gonna try and set up the podium, but this was just so if it does drop again, you don't lose audio. The whole thing doesn't collapse.
Well-
Then it might need to stay on regardless.
Yes, you need to keep your
Okay.
mic
I mean,
on.
Zoom mic.
Yes.
Mic in.
Let's see. Mhm. Why don't you log that computer on? Can that one come on Zoom and we can just put the camera on the podium? On the table with, we're missing.
It's not the computer. This
No,
is-
so you can at least use the camera from there.
It flips back. If you want to use that, that's in reverse. So there's a button where it'll only slide and it'll show.
I can flip your camera to show going forward. Is that what you,
That's fine.
okay.
Serious. Oh, okay, okay.
See if we tilt it.
Nobody will see my ugly bug anyway. All right.
Okay, and that's fine. Like it looks fine when you're sitting down.
Okay, yeah,
And is it fine for me to take a second to still try and look?
absolutely, absolutely, absolutely. So you get that back up. Yeah. Okay. Let's see, this one is, see, the old case is 19 SC 167-544 Antonio Lindell Evans. And let's see, the new case is what, 22 SC 185213. All right, go, what, probation?
Violation and failure to pay fees. On April 24th, the defendant committed the offense, counts of reckless stunt driving, fleeing and attempting to elude police during the commission or certain crimes in Cobb County. And it is in arrears of
Right.
$160 in probation fees, $50 in public defender expenses. Probation's asking, giving a generous recommendation of to revoke 3 months and reinstate the balance. This is, well, the defendant doesn't have a prior revocation, but he does have an agreed waiver of revocation order on file with court and probation. Where we allowed him after testing positive to enter the DRC program. And 2 days after this, that was ordered, he was arrested on the Cobb County charges. We were asking to revoke 3 months from his state.
All right, go ahead.
Donna, good morning.
Good morning.
Thank you, Officer Brown. I want to say to the court that Mr. Evans has been in court in jail consistently since April 25th of last year. So that's 250 plus days. So, and we're about to have April again. He's coming up on a year in custody on this arrest. And when he was initially arrested, he hired me and I filed a motion for bond. And of course, the judge in that particular case out in Cobb, they denied the bond request, given that he's on probation and he had this new charge. And I don't even think that at that time, I filed another motion for bond and it was not considered by the court. It wasn't even calendared. Another 90 days passed. The district attorney's office in Cobb County still had not indicted him. So I filed another motion for reconsideration of bond. And at that point, he had been in custody already 120 plus days. He didn't actually get a court date for another 60 days, another 30 days at the beginning of December. So he was entitled to a bond at that time, and he has a bond. He was aware that there would be a hold for him to come and answer for the revocation here. But Mr. Evans could have been over here a long time ago and answered for this revocation. But as a function of processes in Cobb County that are the subject of a judicial emergency order, he was not. So we are asking you to impose a reasonable sentence in this case, the time served, the time that he has been in custody in Fulton as the sentence, and reinstate his probation so that he can go and release him to the bond today that he has in Cobb County so that he can go and answer for the charges in Cobb.
Mr. Jenkins?
Both Department of Services and Defense Counsel appropriately articulate on behalf of the state and you're relieving your discretion in this matter. And so that's our position. The request is reasonable, certainly, but a correct request by the Department of Community Services is appropriate, Your Honor, and obviously feel very, very much order.
You get out this.
So on this one, you said, how long did you say? It says on here 3 months. How long did you say you want to revoke? 3? You getting credit for his time served in Fulton? You can't, okay. What do you think, Mr. Jenkins? You can't answer?
Corrections in this case, we've done very well. We are parties, so a recommendation tonight.
All right, so looks like 2 months, 28 days, so I'll revoke 3 months, reinstate the balance.
He's been here since the beginning of December,
December
45
18th.
days.
So it's like 2 months and 28 days, somewhere on there.
Okay. So he's got to do the additional 2 to 3 days
Mm-hmm.
before he gets out. And will Your Honor be releasing him to the bond?
Yeah, you want us to just release him to Cobb? They're gonna come get him?
No, he has a bond.
Oh, he has a bond, yeah.
2 more days.
Yeah,
Looks like
How many more days?
3.
3 days?
yeah. Like,
Got 2 months and 28 days in. So,
And his date, well, on here it says it's 12/18/24. Wait a minute.
and so, and that's why I'm asking, Your Honor, like, he's already been in custody. I mean, he's been in custody since April.
No, I'm talking about here in Fulton.
Yes, but I'm saying total on this particular charge, he's almost been in custody for the minimum sentence amount for the charge that he's facing. So we're just asking for the time served.
Let me see the exact date he's been in. Now, let's see right here. One second.
And even throughout the time that he's been in custody, like he's been paying, being consistent about trying to be in touch with his probation officer, but he wasn't assigned one.
So reckless stunt driving, 2 counts, fleeing, attempting to elude. I'm trying to get the count on the jail, like what is,
Thank you.
like dates have been,
Thank
since
you.
been in here, exactly. No, it's here, was it 2018? So I'm looking for. So he's been here for 45 days, right?
80,000 and 10.
Total 45.
Yeah, okay, there you go. I finally found, all right, so what we'll do is yeah, I mean, he committed a crime in Cobb. That's why he served time in Cobb, so he could make bond. So I'll just make it I'll revoke 60 days. So we'll split the baby in the bathwater, all right?
Yeah, no, I appreciate that. So.
With that time he has, for credit for the 45 days.
Yeah, sure. Thank you. So you gotta do another 15.
All right, who's next?
Oh, Mr. Patterson.
Which one?
And then,
You mean invite the podium back?
you don't need to see him.
Oh, is it already back in there? Oh, okay.
So right now, it's just it's not doing anything else.
All right.
If you want to flip your camera back.
How do I do it right?
How do you want to ask yours back?
Want to do what?
Do you want to flip yours back?
Yeah.
So facing, hit that, and then click the one that's just the webcam. That one.
That one. Boom. Thank you. Outstanding.
No problem.
All right, let's see. Who'd she say is coming up, Candace?
Mr. Patterson, I believe she's on the motion.
Yeah, please your one on motions.
So we're done with the probation revocation calendar? There you are. This is,
Oh,
so this is Mr. Patterson
This is Mr. Davis, Judge.
Davis. Okay. Hey,
It's a revocation.
okay, there it is. Rodriguez. Okay. So on the,
Because right now it's just it's just the attorney.
yeah, if you want, you can tell us, I get both of them. Yeah, you can go there and stay here. Let me turn it a little bit. If you want. Thanks. All right, so this is position 8. So it's Rodriguez Davis, 23 SC 185937. All right, Madam Probation Officer, you ready on Mr. Davis?
Want to allege, a new violation of criminal law, Your Honor, in violation of special conditions. The case of, possession or transfer of firearm by convicted felon, reckless driving, driving while license suspended, in robbery, on or about November 5th, 24 in Burke County. And the defendant failed to complete the county violence intervention program. Probation,
I was in my class.
recommendation is to revoke 6 months, state today and reinstate your balance, solely because of the firearm charge. Your Honor, nothing further.
All right, go ahead, counsel.
Good morning, Judge. We understand the seriousness of a firearm charge, especially on a probationer. However, Mr. Davis in this case was borrowing his brother's car, had no idea the firearm was in the car, and he would not have knowingly possessed a firearm. He was very clear on his probation conditions. A couple things that the court should know about Mr. Davis. He's been in 36 days on this violation since December 27th of 2024. Mr. Davis also has extensive health conditions. The end of 2021, he was walking out of a Walmart and walked into the middle of a police shootout. He was simply leaving the store and walked into the middle of the shootout. He was shot several times and lost a kidney as a result of that incident. He is supposed to be receiving dialysis 3 days a week, Monday, Wednesday, and Friday. He has not been receiving that treatment while he's in Fulton County Jail. So we're concerned that his health is deteriorating. So we would ask that he be reinstated to probation with credit for time served, or in the alternative, if the court is not inclined to do that, be allowed to complete the 6-month revocation on house arrest. He is fine with an ankle monitor, any conditions the court would put on that revocation.
So does the one kidney he have just not work?
It's a 70, as long as it's operating above 70%, it can function for the body. And Mr. Rodriguez has explained that that kidney has begun failing. So that's why the dialysis was implemented.
And they know he's supposed to be on dialysis at the jail and they haven't taken him?
He submitted multiple written requests at my direction. I can't do anything as
Right.
to make the jail do anything. And they actually told him, if he submits another one, it's just going to slow things down more.
Do we contact to make sure he gets his?
Your Honor, I don't know that the court can tell the jail to.
Well, I'm gonna
provide-
call, you know what? I'll call Sheriff Labatt and let him know to look into, I'll call Sheriff Labatt and tell him to look into, I mean, I'm not telling him what to do. Don't get me wrong, but I'm going to ask him to look into it. So if he's indeed done that and there's something, then I'm sure Sheriff will get him the treatment he needs.
They don't.
Well, I'm gonna call the high sheriff,
She's going to call Sheriff.
okay? So, he's been 36 days. Anything else from probation? All right, so we'll revoke the 6 months, reinstate the balance, and give him credit for time served. 36 days right now in Fulton, and I'll call Sheriff Labatt. Write down his booking number. I'll call Sheriff Labatt as soon as I finish this calendar.
Judge, do you need any email or anything from me regarding that? Would that be helpful for the court?
Yeah, you can, yeah, feel free to email it. You can email it to Ms. Woods or me and I'll send it. So we'll get that. If something comes up and they don't get it done, I mean, I don't want his health to go bad because of that. Reach out to Ms. Woods, let me know, and reach out to probation, try to do something. Yeah,
Yes,
yeah.
yes,
I'll
I'll get something prepared and put out,
Yeah,
Judge.
and I'll call too. Okay. Thank you, sir. Yeah. 6 months, reinstate the balance. Who's next?
We're gonna shift gears, because I'm gonna smoke and then we're gonna handle that. And now I'm never going here and
We're gonna hear the motion from Patterson. That's the one. This is 24 SC 003048. State
Your
of
Honor.
Georgia versus Kashawn Patterson. Yeah. All right, make sure.
we're gonna see. We're gonna have a seat. Okay, without it, everyone did.
So, Mr. Norman, am I correct? There's 3 motions pending?
There are 3 motions pending. I believe we have stipulations on 2 and an agreement on the 3rd. Just for the record, I filed a motion to sever the offenses. Mr. Patterson is charged for incidents on 2 different dates, a January date and an April date. And I believe my understanding, I don't want to speak for the state, but we've agreed to stipulate that we can sever the January offense from the April offense.
Yes, good morning, Your Honor. The state does not oppose the motion for severance. And because of that, Your Honor, when these cases, if these cases are severance, there is the second motion is to bifurcate the possession of firearm by convicted felon charge. By law, we will also agree to bifurcate that charge.
Okay.
So we can file orders regarding those cases. And the 3rd motion I filed was regarding if Mr. Patterson chooses to testify, his record being not being able to bring up his prior criminal history.
404B, yeah.
Yeah, and so I would, in talking to the state, what I'd like to do is wait until the beginning of my case, and then we can deal with that motion if he is in fact choosing to testify.
All right.
And then I believe Mr. Patterson filed a motion on his own. I am not joining in that motion. And I guess he can address the court regarding that if you'd like to hear from him regarding the motion that he filed.
I got it. Yeah, okay. All right, come on up, sir. Are you familiar, the state familiar with this one?
I'm sorry, Judge.
Are you familiar with this one?
I am familiar
Okay,
with it.
all right, so this is a motion to remove counsel.
Yes, ma'am.
Alleged misconduct and ineffective assistance of counsel. All right, Mr. Patterson.
Yes, ma'am. I'm having, me and my lawyer having irreconcilable differences, and I had stated a claim for which relief could be granted. The last judge, well, Judge Schwartz said I couldn't get rid of him, so the next action I can undertake now is to write the Bar Association to force him to withdraw. He's not helping me in the manner of which he should be. This case never went this far, you know what I'm saying? He never even put in for evidentiary hearing. They have nothing, all I have is statements and accusations this far. I have nothing else. I even have the 911 call to the body cam footage. It's the actual nature of the call. You know what I'm saying? And this is some of the things that I've been feeling like they've been obstructing evidence. The same thing with the phone calls and all that stuff. I asked him to let me listen to the phone calls. He brought me a packet where the victim is saying, I never said that, you know, she's denying this. The district attorney know these things. They keep, nothing ain't going. I just don't want this lawyer no more because he's not doing what he's supposed to do. So now it's becoming an appellate issue. I don't need him on my case.
So
I ask that you please grant relief by removing him.
If I may, Your Honor.
Sure.
Just in response, The motion that Mr. Patterson filed is most related to the attorney that handled the pre-indictment. He did make an allegation that I failed to file his speedy trial motion. That's obviously been filed because he's got a speedy trial date.
Right.
As far as his discovery goes, that was provided to him. He did request an audio recording of the preliminary examination. I contacted the court reporter who said that that did not exist. It is destroyed once there is a transcript. He did request video from a Vivint camera at the residence. Again, by the time I get the case, that exists only for 14 days. By the time I have the case, that video no longer existed. And I believe the third thing he requested is to listen to his jail calls, which he made. I did provide transcripts of a call to him. However, the only thing we can do, because we can't provide a thumb drive to the inmate, is my investigator would have to go sit there for 20 hours for him to listen to the calls that he was on. Aside from that, I have filed motions. I have filed his speedy. I've gone over his discovery. The issues he has relate to factual issues, which are trial issues. However, if he is, if he's not comfortable proceeding with me, I have no problem, withdrawing from the case, but I don't know. I think he would have to hire an attorney at this point.
Hey, ma'am, the calls he's saying that's 20 hours long, that's not true. There was only like 7 calls, and we probably spoke for like, 3-4 minutes. So if you combine them all, it's probably like about an hour at most. And he couldn't even let me listen to those calls.
But you were on those calls, so.
I am on those calls, and there's certain things I want to point out because I already done filed to the district court on habeas corpus on perjury. They got a lot of things. You can't lie about one thing and tell the truth about another. It does not work that way. So there's a whole lot of stuff in there, like the recording that she had for us, the audio. You know what I'm saying? She said that we in a preliminary hearing, she stated that there was some I asked her about having sex that night, and she said that she couldn't. But when the recording starts, it's talking about something else. She perjured in there.
I did not go forward with any facts regarding the case.
It's all factual. I'm saying I'm here for something that I didn't do.
It can be used against you. So here's the thing: when it's an appointed attorney, you can't really fire him. So, I mean, you can, but then they're not going to appoint you another public defender. You got the money to hire somebody?
No, I ain't got the money to hire nobody. But if he ain't, I'm saying I'm being forced to trial with a lawyer that's not working for me. He's not doing none of the things he's supposed to be doing.
Did you not listen to what he said?
I heard what he said. What he said is not true, ma'am.
Just because you say it's not?
No, because I'm saying everything that I've been asking him to bring to me so we can go across it. He don't even have a defense for trial that's in 10 days from now. He don't even have a defense for trial. Nothing. There's and all these charges, the gun just now getting handled. The gun should have been handled a long time ago when he looked at the search warrant and seen that it wasn't specified in the warrant. He should have been took care of that. Why we get to this point 9 months down the road, we just speaking on the gun. Where's the DNA evidence? Did we ever got that back? We just keep moving off of accusations.
They don't have to turn it over to you.
These are all factual issues, Your Honor.
Right. These are all, yeah, definitely.
I'm saying, but he's not doing his job. I'm having irreconcilable differences, ma'am. I stated a claim for which relief could be granted. I'm asking the court to remove this counsel from me, please.
Anything from the state?
Nothing from the state, Your Honor, if you find that, if you grant his motion, Your Honor, the state just asks that there is a speedy filed in this case, if it can be withdrawn and he move forward pro se, if he wishes.
That's being forced to. I have never waived having an attorney. I just said I want this attorney.
Okay, but you can't fire somebody who's appointed to represent. You can't just keep firing them and going through.
I ain't had this the first. No,
I tell you what.
The first lawyer I had on this case, the other one was for preliminary. She withdrew on her own. I never fired her.
Because she's her what she does is preliminary hearings.
Exactly. So I never fired anybody else.
What I'm going to do is I'm going to grant you that divorce since y'all have irreconcilable differences, but I'm not going to remove him as your lawyer. Everything he said makes exact sense. They only have recordings for so long, and he's doing his job, and the state doesn't have to turn over discovery as of yet, probably. So there's timelines. So you need to. All right. So no, I'm not gonna remove him from
my last argument at this here. The victim said I didn't stay at the house. I have a vivid security home system that he can use by my social security number prove that I've lived there.
Okay. listen to me. What you're saying now,
Mhm.
they're gonna get a transcript of this and use it in court against you.
Okay.
So when that person gets up there and says something different,
Mhm.
no, let Mr. Norman do his job. I promise you, he can do a much better job representing himself, you than you representing yourself.
I never asked to represent myself, ma'am.
That's your only choice. Hire somebody to represent yourself.
I just let the bar association just deal with it. I just made this complaint with them. It's gonna be an appellate issue. I'm letting the record reflect that I've spoken to you about it already. I stated the claim for which relief could be granted. You still refuse the motions. I done district court, everything. I keep saying this man is ineffective to me. And I have, under my Sixth Amendment right, I have a right to an effective counsel. And you keep saying, just stay with it, stay with it. And I already know he's not working in my best interest. He's working more in the district attorney interest than anybody.
Okay, so Mr. Norman's your lawyer, unless he just, he finds some reason he wants to withdraw. He's doing everything he's supposed to do.
Mhm.
Sometimes things don't move at the pace you want it to. Okay, next.
Uh-huh.
So who's gonna send me the orders?
I can,
You
I'll
can-
prepare.
Okay, thank you. And so you'll.
No more comments. Get out of the courtroom before you're talking.
Friday before.
Yeah, and everything's been filed, with the exception of, proposed court here.
Okay. And then is there a need for you all to come back and start that short? Or call the jury down on that, on the revocation?
I think, yes, I would like for there to be an offer placed on the record so that it is clear what the maximum and minimum times are.
Can we do that now?
Well, if we can we set a pretrial date? There were statements that the defendant made. They haven't found a Jackson Deno, but we do need to be heard on that before trial. So if we could just put down a pretrial date, then we can put the offer on the record, decide which cases we're moving forward with.
Okay.
And every other business.
All right, I'll send you all an email with that. How much time do you all need for that withdrawal conference? 30 minutes?
Oh, bring it out.
Okay.
Can you do it later in the week?
Yes, ma'am.
Thank you.
You're welcome. Thank you.
All right, thank you, Mr. Norman.
That's Ms. Patterson. Okay, so those are his family.
All right, what's next?
So I'm ready for, your case, Ms. Robinson. Let me find Mr. Burke.
Which case is that? What case we doing next?
Ms. Franklin. Let me find Ms.
All right,
Franklin.
good to see you too. I know you're like going everywhere.
Did Mr. Butterfield have his?
Yeah. Mr. Sanders, I think Mr. Jenkins is wanting a transcript. I think the state's probably want that transcript.
Absolutely. You have another private conversation right there. Come on.
So I'm assuming if they want it, they'll need to give you notice pretty quick since it's on a trial. Yeah, that's what, I mean, pretty quickly because it's on a trial. Yeah, but that's, no, but I'm saying they need to do it quickly so you can get it to them. I just want to make sure. Okay. Yeah, yeah. I just want to make sure they're not sitting there the last day saying we need this. Right. Which case is this going to be? Yeah. Which case is?
In State versus Gloria Franklin.
Is this a plea?
Yes.
Plea. Okay. The plea calendar. Sure.
Was there a separate calendar for a plea?
Yeah, oh yeah, yeah,
Okay,
you're right. I got like 4 different ones, motions.
I just wanted to make sure for the court report.
Yeah, so motions, a plea and arraignment. She's gonna, hey, she's gonna bring you the form if you want the transcript. If you want it for you to fill out, if you're wanting it, because since it's on a speedy, you don't want to request at the last minute. I don't know what her backup is on.
Position 1 on the plea calendar.
This one right. Franklin,
Gloria Franklin.
where did Miss Woods go?
She said she
Oh.
went to go.
Oh, okay, okay, there she is.
I won't be here. I won't be here.
Okay. Cindy.
Can I talk to you over here? Okay, I need to get a corporate report. Yep. That's what I was talking.
Yep, and I sent it a month and a half ago.
It was your Christmas New Year. Too short. I am here. I'm better though. Like I don't know. Wednesday, Tuesday. Oh. Thank you. Still just tired.
All right. Where's Mr. Norman?
So here's what we're gonna do. I'll go ahead and put this on. It's Gloria Jean Franklin, 24 SC 002-075. Mr. Butterfield,
Yes, good morning, Your Honor. May it please the court. Always a pleasure to see you, Judge.
good to see you. Always dressed sharp. I like that tie.
Well, thank you kindly, Your Honor.
All right. We ready?
Yes, Your Honor. May I proceed?
Yeah, absolutely.
Thank you, Your Honor. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court be the truth, the whole truth, and nothing but the truth?
I do.
You can lower your hand. State your true, correct, and legal name.
Gloria Jean Franklin.
And Ms. Franklin, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Medicine.
That medication that you take, does it affect your ability to understand the proceedings today?
No, it doesn't.
And how old are you and how far have you gone in school?
I'm 72. 13 years.
And are you able to read, write, and understand the English language?
I am.
And do you understand that you're charged with the following offenses? You're charged with 2 counts of involuntary manslaughter and 1 count of aggravated battery. Do you understand that?
Yes.
And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty, you may remain silent and you may receive a jury trial.
Guilty.
Nope.
No, I'm sorry.
You just say yeah.
Yes, okay, okay.
And have you had an
Okay.
opportunity to, have you had enough time to speak with your lawyer, Mr. Butterfield, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, I have.
Do you need more time to discuss this case with your attorney?
No,
And are you satisfied with his services?
extremely.
Counsel, do you waive formal reading of the indictment?
We so waive.
And counsel, do you waive any and all defects in the indictment, including any with respect to your client's name?
We waive any defects in the indictment.
Okay. And Ms. Franklin, have you been arrested on the charges in this indictment?
Yes.
Excuse me. The state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
No.
And has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
Yes, he has.
For involuntary manslaughter, the minimum is 1 year, maximum is 10 years. And for aggravated battery, minimum is 1 year, maximum is 20 years. Do you understand?
I do.
And do you understand that this is a guilty plea and it's a non-negotiated plea, and the state may still recommend a sentence to the court?
Yes.
And are you aware of the state's recommendation? And Your Honor, the state's recommendation in this case for count 1
involuntary manslaughter based on simple battery. State's recommendation is 10 years to serve 5 years and the balance on probation. Count 2 would vacate by operation of law, and count 3 aggravated battery. The state's recommendation is 10 years to serve, 10 years to serve on probation, concurrent to count 1.
Okay.
With the special conditions, and I apologize, of 100 hours of community service, no contact with the family of the victim, Miss Jacqueline, Jacqueline, last name Mixon, Mixon, and that you enter into and complete anger management. And do you understand that that's the state's recommendation, Ms. Franklin?
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge in this indictment?
Yes.
Do you understand that do you understand that this plea is a guilty plea, which is permanently recorded on your criminal history?
Permanently? No. Yes.
And do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
And do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
I do.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole, no matter what anyone has told you?
I understand.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
I understand.
And are you asking me to treat it as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced to up to the maximum sentence for each charge in this indictment?
I do.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
I do.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
I do.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not to incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
I do.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
And is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Say guilty under Alfred. I take the say guilty under Alfred. Guilty under Alfred.
And are you pleading guilty because you've decided that it is in your best interest to do so?
Yes.
And are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
And how do you plead to the charges of involuntary manslaughter and aggravated battery in indictment number 24 SC 002075?
Guilty under Alfred.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
I do.
Your Honor, had this case proceeded to trial, the state would expect its evidence to show that on March 1st, 2022, at approximately 9:50, Miss Brianna Gozier, Gosier, ran over the victim in this case, Miss Jacqueline Mixon, who was 78 years old at the time of her passing. After the defendant, Miss Gloria Franklin, pushed her into the roadway on the 6th floor of the Piedmont Hospital parking garage located at 35 Collier Road in Atlanta, inside of Fulton County. Miss Mixon died from her injuries soon thereafter. The security personnel at the hospital provided the lead detective on the case with footage footage filmed by surveillance cameras. It appeared that this was a road rage incident. The victim, Miss Mixon, entered the parking deck behind the defendant, and as they drove through the deck, the victim tailgated and honked her horn at the defendant, appearing to indicate that the defendant needed to drive faster. Once the defendant reached the 6th floor, she parked in a parking space close to the elevator and she got out of her vehicle. The victim walked up to her and they had a verbal altercation. According to the defendant, the victim called her a quote unquote black bitch and turned away from the defendant to walk toward the elevator. The defendant then went into a rage and charged at the victim, forcefully pushing her from behind, which caused her to fall headfirst forward onto the floor, striking her forehead on the concrete parking deck, which resulted in a laceration in the center of her forehead. The victim laid motionless in the middle of the traffic lane, and the defendant then turned around, took a few steps back to her vehicle, retrieved items from her vehicle, and within about 30 to 40 seconds, the victim, who was struggling to move by rolling to her right side and then to her left side, was struck by a vehicle driven by another individual that was coming up a ramp and turned right and ran over the victim. 911 was called immediately, and the victim stopped breathing but was successfully stabilized. The victim later died from her injuries. The defendant left the scene before the police arrived, going into the hospital, where she was later located and detained. Your Honor, the defendant's actions were the legal and proximate cause, as well as the cause and fact of Miss Mixon's death. Miss Mixon did die from complications of blunt force trauma from the torso and extremities. Miss Mixon also suffered blunt force injuries to her head. Your Honor, the state's recommendation, as previously stated, is 10 years to serve 5 years in the balance, probated with those special conditions that were previously mentioned. Your Honor, Miss Mixon's family is present in court, and she was loved and supported by her family. I do have a couple of victim impact statements that I would like to have read. The first one, Your Honor, being from a Pastor James Pitts of Chapel Hill Baptist Church. And Pastor Pitts wrote to the court, "Dear Honorable Judge, I am writing on behalf of Miss Jacqueline Mixon, who was assaulted on March 1st, 2022. Jackie was a woman of God, a faithful church member, and a friend. It was a terrible shock to learn of this assault and later to be with her when she was taken off life support. There is no way to describe what a great person Jackie was. She is sorely missed. Myself and my congregation pray that justice will be served in this matter. Sincerely, Pastor James Pitts. And Your Honor, at the appropriate time, I would like for, there will be 4 statements read from 4 different individuals.
Okay,
And is this the appropriate time, Your Honor?
absolutely.
Thank you, Your Honor. And the first individual would be Miss Mixon's first cousin, Miss Marcia King. And where would you like for her to stay, Your Honor? Just,
Where would you like it, Miss Sanders, so that?
okay.
Good morning. If you raise your right hand for me, you swear firm testimony about gifts, truth, whole truth, nothing but the truth? Oh, sorry, your victim statement. God, I'm just halfway, I'm 4 counters I'm looking at. So all I need you to do, sorry about that, is speak loud enough for Miss Sanders to hear.
Okay.
And if you need to come up here, you can and stand near.
I don't know if I can get through it.
Okay.
Jackie was the flower girl at my parents' marriage. She babysat me and my sisters when she was a teenager. She was a deputy sheriff for Douglas County for more than 15 years. She was very active in the church. She loved to travel and saw many places while working as a travel driver with her late husband, Maury. She loved and supported her family. Whenever we had a family event, everyone gravitated toward her and to see what she had baked and decorated. She loved to decorate cakes, etc. She was devoted to her late parents and tried to make sure their lives were easier. She loved and was devoted to her son, who passed away from leukemia 1 year later after Jackie was killed. In my heart, I will always believe, even though he fought valiantly, that her death contributed to his demise. While her son was undergoing cancer treatment, she drove him to the hospital every day. Because of the pandemic, she was not allowed in the hospital, so she sat in her car in the parking lot reading books and talking to me on the phone. I had major life-altering surgery with major complications. She helped me many a days, talking to me, listening and encouraging me. The last time I saw Jackie was February 10th, 2022. That was my late sister's viewing. I was devastated, beside myself with grief. She held me like a mother holds a child, trying to soothe my grief. Jackie was tragically and unnecessary killed in March of 2022. I never saw her alive again. I never was able to have any more conversations with her. I was never able to say it was okay to meet and be with her beloved husband and parents in heaven. If they had been alive, they would have been so upset to have at how Jackie was killed. I am thankful that they were there to meet her when she arrived in the pearly gate. And I know she was there to meet her son when he arrived. The only consolation is that they are now all together. But why? Why did the defendant put Jackie under a car? I can see no justification under any circumstances for that at all. He took Jackie away from the family, her son and me, when she was needed by us all. And when the defendant did not even stay in that parking lot, but turned around and left to go to her family, leaving Jackie pinned under the car, gravely injured and dying. I ask you, what kind of a decent human being would do that? Please, Judge Manning, the defendant has been allowed to celebrate holidays with her family, work, and carry on her life. We, Jackie's family, have not had those opportunities. Please, Judge, remember the heinous act the defendant committed and sentence her harshly with incarceration. Thank you for your time, Your Honor. As always, Marcia King.
Thank you, Ms. King. Thank you, Ms. King.
Thank you.
I'm sorry for your loss. Yes, ma'am.
And the next individual would be, or individuals are Dawn Pennington and Tracy Bagley.
I got so many counters going on. I can't kind of keep up
And
what's going
that's-
on.
And that's spelled DAWN, last name PENNINGTON. And Tracy, TRACY, last name Bagley, BAGLEY.
Come on, you can hear okay, Ms. Sanders?
I'm Dawn. Jackie was my stepmother. Thought of how Jackie was taken away from us. Her generosity and unwavering support for us is immeasurable, and she will always be remembered as a kind and happy person. We keep asking ourselves why it had to be her. Jackie didn't deserve this. She was such a kind, gentle soul, and she was taken from us in the most brutal way. We are angry that we'll never get to hear her voice again. Angry that she won't get to be a part of our lives. Angry that she can't create beautiful birthday cakes for us anymore or share advice with us. We will always love her, and we will never forget the role she played in our lives. But the pain of losing her like that is something we'll carry forever. We hope this statement serves as a testament to the profound loss we have suffered. Our stepmother was a bright light in our lives, and her absence will continue to cast a long shadow on our hearts. While no sentence can ever truly bring Jackie back, I urge the court to consider the immense pain and suffering this murder has caused everyone who knew and loved Jackie. We believe that a just punishment will not only acknowledge the severity of this crime, but also provide some semblance of closure for our family as we are trying to live our lives without her. Thank you.
Thank you. I'm sorry for the loss of your bonus mom, I like to call them. Thank you both. You got one more?
Two, Your Honor.
Two more. Oh, that's okay. I can understand.
Thank you, Your Honor. The next is Miss Susan Kimsey, SUSAN KIMSEY.
M as in Mary?
M as in Mary,
Okay,
yes, sir.
thank you. You want to just test it out and see if Ms. Sanders can hear you?
You want me to read it?
Does she want, or you want her to read it?
Yes.
Okay.
Your Honor, Jackie Mixon not here to tell her side of the story of what happened on March 1st. Basically, she was killed by the defendant for nothing. Your action took a mother, grandmother, great-grandmother, a sister, a friend away from us, which has haunted our lives since that day. The defendant action took Charles Kimsley, mother, her only child from him, as he was battling leukemia, AML, and really needed his mother. Charles Kimsley was her only son, and there was nothing she wouldn't do for him. She was always there for him, and no one could have better mother than she was for him. The pain, hurt, and anger, the loss of losing his dad 2 weeks earlier to COVID, the defendant's angry state caused him to lose his mother life. To lose his mother life, within 2 weeks apart, being the only child, the pain across his face was so much emotion, no one could understand the pain Charles felt. No one could bring his parents back, and we understand everyone dies, but under the circumstance that the defendants caused Jackie death was showed no She showed no remorse, no emotion for her action. The defendant has some anger issues that shows that is not her first go around. This is the first time she got caught. The defendant didn't care for human life. If she had, she would have stayed and tried to help. Instead, chose to leave the location, never even looking for help at what she had done. No one should have to live with that kind of stress hanging over them. Jackie Nixon had retired from Coca-Cola, Douglas County Sheriff Department, which for over 10 years she was patrolling the streets, putting her life on the line every day. She worked, and for something like this to happen was unthinkable. If the defendant's anger wasn't out of control, Jackie would still be alive, would still be here. The life Jackie had was an adventure, and she loved to travel and enjoy life. Jackie and her son, my husband, zip-lined across the Grand Canyon. Jackie was also busy and doing things. Her energy level was off the charts for her age. Her sane age is just a number because she still worked at John Thornton Chevrolet, driving cars and trucks across the states. Since her son, my husband, got sick, she slowed down to help take care of him. No one can love you like a mother, she always said. Survived cancer several times, and for her to die that way is just unspeakable. She was loved by so many. If the action of the defendant anger hadn't got to her, Jackie would still be here. But I hope justice will help close this matter so we can move on. But the sadness and pain will never go away. It haunts me how people are so cold to human life. Knowing this day was coming has been haunting us for 2.5 years, but I am glad we will finally get some closure today. But not just for my husband and me, but for our whole family and friends who love her daily. The horror, sick act the defendant did on March 1st, Jackie will finally get her justice, even if she has no remorse for life. No one should have to indulge the circumstances Jackie went through. Life support kept her alive for 11 days, and Charles Kingsley, Jackie's son, was there even though he could barely get around himself. He tried over and over for justice for his mother, but the hurt and painful circumstances of him losing his mother was more than his body could handle, and he passed away a year later with a broken heart for his mother. Thank you, Susan Kimsey.
Thank you, Ms. Kimsey. I'm sorry for your loss.
In your honor, the last statement is from Ms. Mixon's son, Mr. Charlie King, brother, I apologize. CHARLEY, last name King, KING.
Okay. Good morning, Mr. King.
I'd like to thank members of the family and community that presented statements this morning.
Yes, sir.
I'm Charlie King, the brother of Jackie Nixon. There were 13 years between us, which meant she contributed a lot to my upbringing, all the way from changing my diapers to teach me how to drive. She was particularly influential in my teen years, keeping me out of trouble. I'm writing this statement to share the profound and lasting impact Jackie's violent senseless death has had on my family and her community. My sister was taken from us in the most unimaginable way, pushed under a moving car, a senseless and cowardly act. The images of that moment and the knowledge that my sister was murdered so violently haunt us to this day. Her life was violently and intentionally taken from her without stopping or calling for help. The culprit just walked away to continue her day. Especially hard hit by this tragedy was my nephew, Charles Kimsey. Charles's father died from COVID, and 2 weeks after the funeral, his mother is pushed under a car and dies from her injuries. Both parents gone in 2 weeks. Jackie was with Charles 24/7 for over 2 years through his battle with leukemia. Less than a year after his mother's death, we buried Charles also. The weight of Jackie's death seemed to stunt Charles's recovery. Financial impact is also significant. Grady Hospital put a lien on her house for expenses, thinking there was more money to collect from any lawsuit monies family might receive from Medicare. After 2.5 years, Grady finally dropped that lien last week. There are still legal and probate fees to be associated with Jackie's death. Jackie was full of life and kind, always ready to lend a hand to anyone in need. She was a light that has now been snuffed out. It's our reality, and it's one that we'll never recover from. I hope that by reading these statements, the court understands the depth of pain and suffering many have endured because the sentence had. My sister's life was stolen and will never be the same. No sentence can bring her back, but I ask for justice for her so that no one else has to endure the pain and loss that we have. Thank you for hearing our statements.
Thank you, Mr. King. Mr. King, let me ask you a little bit about your sister. So when did she work at the sheriff's office in Douglas County? Which sheriff did she work under? Earl Lee?
Earl Lee.
Oh, okay.
I don't live in Douglas County, so I'm not really.
Well, there hadn't been too many in the last, 30 years. Earl Lee was there forever.
Yeah, he was.
Yeah.
How much I do recall, because we were good friends with my brother-in-law at the time. He was bailiff in the court system there, so.
Now you don't live in, where do you live?
I live in Kennesaw.
Oh, okay. All right. All right. Well, good. So what's your most favorite memory about your sister?
Back when I was a teenager, she, not to get into details, but she pulled me out of a lot of trouble.
So she covered for you.
Well, cover, advice, and spoke to the court. But but no, she I used her for guidance because of the differential in our ages. She'd already been through that. We went to the same high schools and stuff. She even gave me tips on teachers that I was going to be facing in high school. But she was always there. She would see stuff coming and tell me, and I could make better judgments in my life. I guess that's probably the best way I could put it.
That's definitely a good sister. Definitely a good sister. Hopefully, if you have children, they learned and they're good to their siblings.
We're working.
Well, thank you so much. And I'm so sorry for your loss.
Your Honor, the state is showing no felony history for Ms. Franklin. And the state would object to the Alfred plea, but we do understand that it's at the court's discretion.
All right. Mr. Butterfield. Okay.
Judge, I want to speak with you a little bit about Miss Franklin, and then I'm going to speak with you a little bit about the case. And we have multiple people on Zoom calls, and we have folks inside the courtroom here also supporting Miss Franklin. But Judge, as she stands here now, she's 72 years old. And back on March the 1st of 2022, and I met her shortly after that, I've been a part of this case from day one, Miss Franklin was 69 years old. She had been retired. She's now been retired for about 9 years, and she retired from the CDC. She was a program analyst at the CDC, where she recorded birth defects and did calculations. She worked there for about 13 years. She was born and raised in St. Louis, East St. Louis, Illinois, rather. And in 1980 to 1982, she worked at the Record Center doing their vital records in St. Louis. So she's always worked in government. She moved to Atlanta in 1983, and she worked for the Department of Defense, working at Lockheed Martin from 1982 to 1997, where she was an accounting technician there. And then after that, she worked for Equifax from 97 to 02. And then she worked for the CDC. She has one daughter, Monica Franklin, who is in court with her today. She has a grandson who is now, was 17 back then, but I believe it's 20 at this particular point. And that's just a little bit about who Miss Franklin is by way of her, a little bit of her background. I have some other folks on the Zoom call who are going to speak a little bit more about her, but I'll tell you, Judge, in this particular case, Miss Franklin is taking a plea in this case. She does believe that considering all the facts and circumstances, it is in her best interest to resolve this matter. She's always been remorseful, and I'll talk about what she told the police on day one, but I've struggled with this case, Judge, for about 3 years now. And what I've struggled with in looking at this case is how it is that the driver, Miss Garcia, could run over Miss Mixon in the parking deck of Piedmont Hospital back on March the 1st. I've been out to that parking deck prior to this incident, after this incident. It was not crowded at the time of this incident. It was well lit. It was wide open, and there was no speed limit there or nothing preventing the speed. And it boils down, I believe, that Ms. Garcia simply was not paying attention. She had a person in the car with her. We didn't get the records to determine if she was on the phone, but in this particular case, the eyewitness in this case, Mr. Michael Thomas, he had gotten off the elevator. He saw Miss Mixon there, was going to help Miss Mixon. And he said, I thought the driver saw her. But he says, next thing he knew, she hit the woman, this is what his statement says. And he's like, hey, stop. And she's like, what's going on? And the young driver gets out oblivious that she has run over a whole human being who had been there for quite some time. This is not a case when this case was in the media when it first occurred. It alleged that Miss Franklin pushed Miss Mixon into oncoming traffic as if they were on the highway or something. But we'll talk a little bit about that. But they should never push Miss Mixon into any oncoming traffic at all. In this case, Miss Garcia could have been charged with vehicular homicide, misdemeanor version of it. But in this case, Judge, as I struggled, there was an intervening cause of the death of Miss Mixon being this negligent driver. But one thing that's always remained clear is that Miss Franklin never intended to cause any injury, harm, definitely not death to Miss Mixon. When she talked to the police that day, they said that Miss Franklin states she didn't mean to cause any harm to Miss Mixon or her death if she dies from her injuries that she suffered. And Miss Franklin was very remorseful when learning of Mixon's condition, and she never meant for any of this to happen. She was upset when she was called a black bitch. So what really happened out there on that day when you consider what Miss Franklin told the police? She had gone to the hospital that day, Judge, on March the 1st. She too had an only child, has an only child, Miss Monica Franklin, who was at the hospital for some serious surgery. And Miss Franklin had been to the hospital, but at this time there was construction at the hospital. And she was there very early to get there to the surgery. And when she got there, because of the construction, she didn't know which date to go in. So she was confused and she was trying to get to her daughter. And as she pulled into the deck, someone behind her was blowing the horn. Miss Franklin says she noticed the sound, but she didn't turn around because she was nervous and she just wanted to get out of the way and park. And after that, she continued to drive, and the person was continuing to blow the horn, and she was looking for a space, and she went all the way up. But Miss Franklin said she never turned around. She was just doesn't know who was blowing, but she was just looking for parking. At some point, when she got to the 6th floor, she got out, she was gathering her bags, and that is when she saw a person coming down, and the video shows all of this. It shows Miss Mixon coming down, and it shows Miss Franklin there. And Miss Franklin said she was trying to explain, ma'am, are you the person who was blowing at me? I want to explain, like, my daughter's having surgery. I was not trying to, cause you any harm or any inconvenience. And as she was talking to Miss Mixon, Mr. Franklin said, and they say there was a dispute had. You can see them talking. Miss Mixon stated she didn't want to hear that. And then she said, and Miss Franklin still said, well, my daughter's having surgery. I just wanted to tell you, I didn't mean to, impede the traffic. And Miss Mixon said, I don't want to hear that. And she walked off and said, black bitch. And it shows Miss Franklin look, and then in Miss Franklin's mind, as she sits here today, she believed that she was going to tap Miss Mixon on the shoulder, say, man, did you call me a bitch? But we know now she did push Miss Mixon down. Miss Mixon, she didn't fall to the ground. She stumbled forward and she fell. She was not unconscious at the time. You can see the video and Miss Franklin is there. Miss Mixon is moving around. And what she told the police that day is, oh my God, I don't want to do anything more to touch this woman. She's already on the ground. And at that point, and she told them, she said she didn't know if she would be sued or anything. But at that time, Miss Mixon was not unconscious. She thought she was going to be fine. And there were people around. We know that Mr. Thomas got off the elevator. Miss Franklin goes back to her car. She walks to her car, gathers her things. At some point later, that is when the young driver comes around and for some inexplicable reason does not see Miss Mixon. And there's quite some distance when from the time her car enters the video to the time she runs over Miss Mixon. That is what we have in this particular case, Your Honor. This was an unfortunate, tragic incident, but it was an accident by every sense of the word. Some would say, well, had she never pushed it, we wouldn't be here. But there was the intervening cause in this case. But considering all the facts and circumstances, Miss Franklin wants to get this matter resolved also. In this particular case, Judge, we have some folks that we want to speak with the court about, and then I will talk to the court about what it is that we'll be seeking. If you give me 1 second, Judge.
Sure. Ms. Sanders.
Judge, at this time, we have some character witnesses. They will be brief and they're going to talk a little bit about Ms. Franklin. If I may call them at the court's pleasure, and then I will.
Absolutely.
Judge, on the screen, there is Melissa Murray on for Gloria Franklin. If you could turn on your camera and then turn on your microphone, please. Please raise your right hand. Do you swear or affirm that the testimony which you're about to give here today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. State your name and tell us how old you are.
Melissa Murray, and I'm 64 years old.
And Ms. Murray, are you married, single, divorced, or widowed?
Married.
If you have children, tell us how many and how old they are.
I have no children.
And what do you do for a living?
I am an insurance agency owner and have been for over 40 years.
Tell us how you know Miss Gloria Franklin and how long you've known her.
Well, I originally met her as a client nearly 40 years ago. And just through the years, she became a close friend just from her caring nature and who she is. She's just somebody that I was drawn to naturally. And she was always helpful and kind. So she's the kind of person that I would like to be a friend with.
And over the years in spending time with her, have you come to learn her reputation for honesty in the community?
Yes, Gloria, I've always known her to be a woman of honor and integrity. And I personally have never really even known her to tell a lie. I mean, she may have told a white lie in her life, but I've never even experienced her to tell a lie.
And have you come to learn her reputation for peacefulness and nonviolence? I mean, is she the kind of person who has a violent nature? Or tell us about that.
No, I've honestly never known Gloria to be violent or exhibit anger of any kind. I mean, I'm honestly baffled that she's even mixed up in something like this because I can't imagine what the conversation was or what would have provoked her to even be angry enough to touch her. I mean, the language was bad, but that's just not the Gloria I know. She's always wanting peace and helpfulness, and she's always been an inspiration to me because she is a strong woman of God who is serious about her faith and her relationship with the Lord. And she has her morning quiet time and Bible study every day, and she's always willing to offer you an encouraging word of scripture. And I thought the other day about the fact that she has that even on her voicemail, if you get her voicemail, she's offering an encouraging word of scripture on her voicemail. So, I mean, this is a woman that inspires me, and I have just been baffled since this whole thing happened. I just couldn't imagine Gloria being involved in anything like this.
And lastly, can you give us one of the experiences that come to mind that characterize who Miss Franklin is that you can share with us?
Well, the thing that comes to mind mostly is just her helpful nature and her kindness. And I have an insurance agency, as I mentioned earlier. I had a new office manager at the time, and she got to know Gloria through just handling her account. And she mentioned to Gloria one day that she was having to pack her mother up and move her into an assisted living home. And Gloria offered to come help her pack and move her mother. And she didn't have to do that. I mean, but that meant the world to Deborah that she offered to do that, and she actually did it. And Deborah was just, amazed that a client to her, she was a friend of mine, but at the time that this happened with Deborah, she was just a client, and she offered to come help her. And then years later, when my husband and I bought our new home and moved, she did the same thing for me. She found out we were moving, and she offered to come help us pack up and move. And that was a blessing as well. So, like I said, that's the kind of person she is. I don't know what to say. It's just, I'm still baffled that anything could have provoked this.
Well, thank you very much for being here today. The prosecutor, Ms. Robinson, may have a question, may not have a question, and maybe the court, but thank you for answering my question.
Sure, thank you.
No questions.
Right,
Okay.
thank you. And you may be excused if you need to, or you're happy to
Okay. Can
continue
I
to
say
be.
one more thing?
Sure.
I'd like to say that just what I've had in my mind this whole time for the last 2.5 years is that the Gloria I know would never, ever intentionally hurt anyone. She's a helper. She's a blessing. She's not someone who wants to harm anyone.
All right. Thank you, Ms. Murray.
Thank you, Ms. Murray.
Yes, the next witness here I'm going to call, Your Honor, is, I believe, Ms. Linda Harris is on the, Ms. Harris on the call. Yes, and then there, please turn on your camera and turn on your microphone, Ms. Harris. Please raise your right hand. Do you swear or affirm that the testimony which you're about to give here today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And Ms. Harris, state your name and tell us if you're married or single.
My name is Linda Harris, and I'm divorced.
And do you have children? And if so, how many and how old are they?
I have one daughter, and she's 44 years old.
And what do you do for a living?
Well, right now I'm retired.
Okay, and from where did you retire, your last job?
Okay, I retired from the Department of Defense with 39 years.
And tell us, how long have you known Gloria Franklin?
Might as well say all my life.
Okay, and since you've known her, you spent time with her?
Yes.
And can you tell us, have you gotten to know her reputation for honesty in the community, and is it good or bad?
Yes, I have, and it's good. I'm like Miss Mary. When I first heard about this, I was stunned because, again, like she stated too, and I agree, that's not the Gloria that I know. The Gloria that I know is always there for people, wanting to help them. Anything that she could do for not just family, but for friends, she would do. So I'm still struggling with this as well.
Okay. Thank you very much for being here today, Ms. Harris. And the state might have some questions for you, or the court.
No questions from the state.
Right.
Thank you.
She doesn't have questions, Ms. Harris, so you can stay or you can go ahead and go if you like.
I would like to stay, please.
Okay, and thank you for your statement.
Judge, the next witness we're going to call is Mr. Marcus Macon, Macon. Mr. Macon, please raise your right hand. Do you swear or affirm that the testimony which you're about to give here today will be the truth, the whole truth, and nothing but the truth?
I do.
And tell us a little bit about yourself. How old are you? What do you do for a living?
I am 61 years old, and I am the supplier inclusion manager for Lowe's Home Improvement.
And tell us, how long have you known Gloria Franklin and how do you know her?
I've known Gloria for over 40 years. She is my sister. I would say sister-in-law, but she is my sister. I consider her a sister more than I do a sister-in-law.
And since you've known her, did you come to learn her reputation for truth and honesty, and as well as her reputation for peacefulness and nonviolence? And if so, tell the judge a little bit about Ms. Franklin, please, sir.
Oh, absolutely. Well, as I said, I've known Gloria for over 40 years. When I met Gloria, I was fresh out of college, and right away, being the oldest of, I believe she has 7 siblings, you could tell that she was the caretaker and caregiver of the family. She's always been that person that's been there for everybody, putting herself last and putting everything else in front of it. Countless times, she's allowed people to come and live with her, sisters, brothers, nieces, nephews. She's always been the refuge when needed. And again, you know, very self-sacrificing. I have 3 sons, ages 39, 34, and 30. And she has been the most amazing aunt to all of them. Again, time and time, I've been through situations just growing up and just having challenges and hardships. And she's always been there for me. And I'm no longer married to her sister, but yet her relationship and mine has always been intact. We're very close. She constantly checks on me. I live in North Carolina. I'm not in Georgia anymore. But we stay in touch. She constantly checks on me. And she's just an amazing person with a very big heart. As everybody has said, this whole situation is just so challenging and baffling to me, especially when I first heard of it and that she was involved, because it's just totally opposite of her character and anything that I've ever known her to do in over 40 years. And my heart and condolences go out to the family for their loss as well.
Thank you very much, Mr. Macon. I don't have any other questions. The state or the court may have questions for you.
No questions from the state.
Thank you.
All right. Thank you, Mr. Macon. You can be excused or you can stay here as well.
I'll stay. Thank you.
Okay, thank you.
Judge, on the call, you'll see Lakeisha Jones, Sarita Young, and others. Due to time constraints, we're not going to call them, but to a person, we believe each and every one of those other persons would have said the same thing about how long they've known Ms. Franklin, that she's not a person who they know to be a violent person, anyone who's ever been in trouble, and that she is a giving, caring person from what they've known, and she's very spiritual. So we're not going to call those folks, but they are welcome to stay on the call. At this time, Judge, Ms. Franklin does have a statement that she would like to put on the record, Your Honor.
Okay, does she need a minute before she?
She says she's okay, Your Honor.
Okay.
Madam Court Reporter, she's going to try to speak loud enough for you to hear.
Mr. Butterfield, I guess if you want to, she could sit there because will that microphone pick it up enough, Ms. Sanders, do you think, or? Oh, it's not, oh, it's just coming through here to be on the recording, okay. Yeah, yeah, because they're coming through instead of the podium.
I didn't want to put anything down, but I didn't want to forget anything either.
I'm sorry, Mr. Butterfield, I'm sorry, so.
Okay.
Yeah, I'm sorry
It's okay.
to make you start over, but the court reporter has to hear what you're saying.
Okay.
Yeah, you could, there you go. If you stand closer up here, she could probably hear you.
There are a number of people that I have disappointed by not doing the right thing. First, my Lord and Savior that has forgiven me. Second, my family, and they've forgiven me. I pride myself and intentionally do what will make them proud of me, and they've forgiven me. And today, I asked you to forgive me. Doing the right thing has always been an important aspect of my life. I failed to do the right thing on that day, that devastating day 2 years ago. Please forgive me. My heart aches as well. And the sorrow and the pain that you've gone through, I've gone through it as well. And I know it can't be mended and we can't bring her back. My desire to fix things on that day became a detriment and a long, heart aching situation for both our families. If only I had done the right thing and just walked away, but I didn't. I wish that I could have the satisfaction of holding Miss Mixon and asking for her forgiveness. However, I believe what the Bible says, and that is that we will recognize one another once we're in heaven. At that time, I'll do it. I pray that one day your hearts will forgive me and know my heart hurts as well. I'm sorry. I'm going to continue to praise God and thank Him for never leaving me in spite of my actions.
Judge, in this particular case, Your Honor, with regards to sentencing, I am asking the court to sentence Ms. Franklin as follows. First, I'm asking that you not follow the state's recommendation and send Ms. Franklin to prison. When we talk, as the court knows more than I do, the goals of sentencing, whether that be deterrence, rehabilitation, incapacitation, which is what the state is seeking, retribution, and then fifth, restoration. In this particular case, there is no benefit, I would say, to society of Ms. Franklin being in prison based on this particular case, which was a tragic case with an intervening cause. And most times, we want to send people to prison who are a danger to society. We keep them in prison from harming the community. And in this particular case, I don't believe there's any future dangerous argument with regards to this case. We are based on Miss Franklin's history and lack of involvement, never been arrested prior to this case, never had any problems. She's not known in the community as, oh, she got away with it in the past. She's not known as a fighter. She has always been known as someone who's been a giver and a supporter. And in this case, the battery case does stand, Judge. We ask that the court sentence her as follows, Your Honor. 10 years to serve on probation, that she have no weapons while on probation, that she have no illegal drugs, that she does 100 hours of community service, that she have an anger management evaluation and treatment if necessary, Your Honor, and for any other terms and conditions to this court that this court would deem just and proper. Judge, I think I've said all I can say in this matter, and I think I've said all I can say in this matter. This was seriously a tragic incident with this intervening cause, and we believe that the court will make a wise decision in this matter. So thank you for hearing from us, Your Honor.
Anything else from the state?
Your Honor, nothing other than the state does have the video available if Your Honor would like to see it, but I know that is at your discretion.
For me to look at it in camera?
Thank you.
You have it? Did she email it to you?
Got an email. I have it.
Oh, you have it? Yeah, can you, yeah. Yeah, I can look at it real quick. Ms. Sanders, if you want to stand, if you want a quick break.
Okay.
Mr. Butterfield, do you want to see it?
I've seen.
Oh, you seen, okay.
Yeah, Your Honor, if the court wants us to go back, I'll go back, but if he has on the laptop.
Bring it to, okay. Bring it, okay. Right back.
Took it off the live and so it's on.
It's still on, you can, I'll mute my,
I don't have access.
no, I'll mute myself. I'll mute my, I'll mute mine. Oh, I just told her. Hmm.
I usually have one of them.
So after this, Ms. Woods, what are we doing after this? No, I mean, what are we doing after this play? Okay,
With, Ms.
all right.
Ms. Robinson, and then Mr. Adams might have a plea. Okay,
All right.
and then, what do you call this, statement from Mr. Gray, Mr. Wright.
Can't hear. Can you hear now, Mr. Ray?
No, no, no,
Oh.
no, no, see he sent a message.
Oh, okay. Addressing technical difficulties. Oh, how long? Oh, by mine's like, let's see. Oh, okay, I got you. Okay, now it's it. Okay, we're back on the record. So there was someone on here named Reginald Ray,
That's what I'm.
and I don't think he's on there now. So I'll read everybody what it says. It was a message to everybody, but I don't think anybody else could see the chat except for, us. It says, sorry I have to drop. Just know that Gloria Franklin has been a second mother to me and I think it means instrumental in my success as a father, son, husband. She would give anyone their shirt off her back, and I extend my condolences to Miss Jackie's family. I'm not sure if there's a relation, but that was from Reginald Ray, R-A-Y. Okay, so we're back on anything else from the state?
Nothing.
Okay, anything else from you, Mr. Butterfield?
Nothing from the defense at this time.
Okay, so I'm sorry it took so long back there. We had a little bit of technical difficulty connecting to the internet, but I got to see the video, and I'm really trying to wrap my brain and not saying anything about like why this lady driving the car wasn't charged with something. Because she obviously wasn't paying attention. I know there's the whole cause and effect when stuff happens. And it started out with Miss Jackie coming over and saying something to Miss Franklin, and Miss Franklin obviously got, a little upset and did push her, but unfortunately, she was there for a while, so I'm not sure why the lady didn't stop the car and why she's not here. But, it happened, and I understand, and I am so sorry for your loss of Miss Jackie. For her brother. Let's see, Miss Susan Kimsey, Mr. Charlie King. Miss Dawn Pennington and Miss Tracy Bagley. If I missed anybody, I'm sorry. My sympathies go out to all of you. And I've heard people say a lot of times the end of a criminal case isn't usually closure for people. I don't know. I think your closure is going to have to be it's between you and whoever you worship and what you can do for yourself. listening to all of you, I felt like that I got to know Miss, Mixon, and I hate that I never got to meet her. It seemed like she was a very nice lady and meant a lot to a lot of people. Miss Franklin did push her. And someone's life did get ended, but got ended by a car. And I'm not saying Miss Franklin isn't, somehow responsible, but I also know that sentencing is for people that are danger to society, danger to the victim, victim's family. They're going to reoffend. And I don't see it. And I've had, and I will tell the family, I've had taken many pleas, one in this courtroom, and you have victim impact statements. And I have to say thank you to Ms. Franklin, because most people that do victim impact statements, the defendant just looks straight ahead or looks down. And I hope that y'all felt the sincerity. I think she was sincere in listening to every word that y'all said. And she turned and spoke to y'all and didn't make her apology about her, which I think is remorse, which I think is, and it may have to do something with her maturity, and that she's, this isn't a regular thing for her. So here's what I'm going to do. And like I said, I have to take into consideration everything. I know the state wants prison time, and I don't know how that's going to help anyone. But it's not letting her off either. I think I'm going to do 10 years on probation, 100 hours of community service, anger management and treatment if necessary. And I think you can, where are they allowed to do community service, like at churches and stuff like that? Okay. No further contact with the victim's family. No drugs unless prescribed, no alcohol, and no weapons. Do we know how much like the funeral was for?
I can speak with the family.
Do you want to ask them real quickly?
Yeah, sure.
Yeah. Mm-hmm.
Depends on much.
Your Honor, speaking to the family, I believe that it was about 15,000, but Ms. Kimsey indicated that she has that paperwork at the house. If the court would be inclined to leave that portion open.
And if she gets it and can get it to them. So, in a lot of civil cases, people get money damages to make them whole, or some of the civil lawyers call that justice. But I'm gonna have her reimburse you for those funeral expenses. And she can make, what did we figure out last time? She made the payments through probation. Is that what we said last time?
Yeah.
Yeah, so you'll do it through probation. So it'll be payments, okay? To pay for this, the burial of the victim. Anything else you think, Ms. Franklin, you need?
I need forgiveness from the family.
Yes, ma'am. Yeah,
And I know it's gonna take a while because
Yes,
there
ma'am.
was a family member, but I need the
Yeah.
forgiveness.
yeah, it probably will.
Yeah,
They all seem like really good people, so
Yes.
I'm soon,
understood.
you know, and you forgive yourself.
I have.
I think it's gonna take longer than, yeah, that's probably harder than anything. But I'm so sorry for, the loss of Miss Jackie.
Absolutely.
Anything else you want to state? It'll be, 10 on each count run, concurrent.
What does that mean?
Your Honor, I.
Oh, the second one merges, doesn't it?
The second one
Vacates, yeah, so it'll be 20 years. Yeah, 10 and 10. They run concurrent, sorry. Second count will vacate by operation of law. And I think,
Would you do that, Judge? We did ask that she be sentenced under the First Offender Act, 42, -8 -60, Your Honor. So we asked that she be sentenced as a first offender in this matter. She does qualify, has no priors at all.
what says the state?
The state wouldn't have an objection for the first offender treatment. However, the state, and I know this is the second portion of it, would object to the Alfred.
All right,
And as from based on everything the court's heard as well as the video, the court can, I believe the court can see why we are resolving it as an Alfred plea, Your Honor. So we ask that it be first offender as well as the Alfred plea. And also for Ms. Franklin's purposes, for any potential civil type cases, that's why we're seeking the first offender and the Alfred plea, Your Honor. And just based on the facts of the matter, facts of the case.
could y'all allow it under first offender? Now, Ms. Franklin, I'm sure your lawyer told you, you could get something like a speeding ticket and then you go to prison for 10 years.
I understand, Your Honor.
Okay,
I understand wholeheartedly.
all right. And I'll take it under Alfred for the family there. She knows if she's six, if she'd go to trial, she would be found, there's a good chance she'd be found guilty, and she's still pleading guilty, but it's under Alfred, she's not admitting or denying, but she thinks if it went to trial, there'd be a good chance that, she would get convicted. And I'll let her do it under Alfred, but I feel like Miss Franklin's pleading guilty and is probably asking for the Alfred through advice of her counsel. So I don't think she's trying to avoid responsibility. Is there anything else that I can do for y'all?
Nothing from the state at this time.
And finally,
Yeah.
I do apologize. How long would that be open as far as the reimbursement portion?
So
I did just want to get.
it's roughly 15,000, said the family, right? Somewhere in there?
Yeah, sure.
Okay,
I did speak with Ms. Franklin about whether or not any restitution would be a deal breaker for her. She states that she would like to go forward with the plea. She understands that she'll have time to pay it over probation, but she just, because she wants the court, we talked about the court could add, and she says she still wants to go forward, Your Honor, and resolve the matter.
so you just, break it up into equal payments, I guess? I don't know if you live on a limited income or what you're,
Yes, Your Honor, Social Security.
okay. Are you gonna,
Determined. So we're waiting. You want a date of when
When
your final day. How long is it gonna take the family to get that documentation to you?
I believe I can have it by the end of next week. Ms. Kinsey indicated to me that she does have that paperwork at home, but they don't have the total cost.
Is that something that everybody needs to?
Yeah, I could be back. We could do it via Zoom, or if it's submitted, we may not have to come back once they submit it. We may say, okay, well, they've submitted the document to show the cost.
Is it 7th later? Is that good enough?
That's
the
next Friday? Yes.
fine. That's fine with us.
And then we can just do it via Zoom if there's a need to. include you all in email,
Correct.
Yes.
and then prepare an order so that probation will know and know who it needs to be paid to.
And how she can pay it. I don't want her to do without food, shelter and clothing.
And that brings with regards to her paying it swiftly, we would ask that the court, although by law she's entitled to a bid date, we would ask that she actually put a bid date in here of 3 years from today's date with regards to in the sentence, Your Honor. Give her this.
Objects, if the restitution is paid by the bid date, then I will agree to the.
Yeah. But yeah, that's what the bid date is for, to make sure that if a probationer gets everything done in a swift fashion. So
Right.
it's by law, by law it operates, but we all still like to ask that it be put in there. But and finally, Judge, since the court has granted the first offender under 42-8-62.1, I would like to submit an order to the court sealing the first offender for purposes of any federal benefits and everything else. I would like to submit that to Your Honor also.
Okay, any objection?
The state would object, we wouldn't object to it being sealed, however, we would object for it to being sealed on the front end versus back.
Yeah.
It's always sealed on the back end by law, and
Well, when I say the front end, what I'm indicating is, I know that we need to get all of this paperwork in order before it's sealed, because I know that it's more of a hassle to try to unseal it, to try to file additional documents.
oh no, yeah,
So like in a few months.
Yes, or
Really upon finishing,
yes, no objection to that.
so whenever everything's
I'll
finished.
prepare it and
Okay,
submit
yeah.
it.
Whenever everything's finished, everything
thank
needs to be it.
And we have nothing further from the defense at this time. Your Honor.
All right, thank you, Ms. Franklin.
Thank you, Don.
Your Honor, that concludes my business with this court. I believe I'm going to meet with probation with Ms. Franklin, but after that, may I be excused?
Yes, sir.
Thank you. Have a good weekend.
To the Mixon family, I'm truly sorry for your loss, and I hope personally that you haven't seen the video. Just don't watch it. It's not, you don't want to see it. But due to the lapse in time and a lot of stuff, there was no oncoming car when she pushed her. There was several minutes before a car came. I understand. I know you're shaking your head, but I mean, it's not like there was a car coming. She pushed her into it doesn't make it any better or any worse, but I just want you to know there was. Oh, I don't know about that. I mean, I guess you could talk to the state, but seeing it and watching everything, it kind of made me make the decision and whether or not she's going to do this again. But I'll keep all of you in my thoughts and prayers, and I apologize for your loss. Thank you all.
Thank you, Judge.
All right. Yes, ma'am.
Oh, shit. But
Oh, God.
if it's gonna. Okay. Yes, ma'am.
Oh, yeah, Adams. Oh, on the bond.
Oh, okay. So it's an offer. They don't know if it's a plea.
Put it on the record.
What case? I'll be back. Oh, sorry. Who's gonna give me a little bit? One y'all gonna send me?
Which case is it?
I know what position is on the calendar.
Oh, I'm gonna give it to you.
Yes.
True. It's, the motions calendar position 3, State of Georgia versus Star X, Warrington.
Okay.
But I get it to you.
Yes. You're gonna.
Outstanding. On behalf of Mr. Boynton, who's present, Your Honor,
Oh.
Yeah. Ms. Woods?
Need position 3 on the motions calendar.
All right, so you got that, Ms. Sanders, 17 SC 148689 Starrett, Boynton.
Anything in the future?
Your Honor, thank you. In this position, Judge, states understanding that the motion was filed by a member of our office. I have had an opportunity to speak with the counsel in this case and reviewed the matter. At this time, I'm going to put it on the record, the state is withdrawn, and the issue is moved at this point.
And we have no objection to that, obviously, Your Honor.
Okay, withdrawing the motion. Okay. Thank you both. Thank you.
Thank you. And may Mr. Boynton be excused?
Yes, sir.
Okay, that's it. Thank you. I appreciate it.
Thank you, Judge.
Uh-huh. What are we doing next? Oh, Mr. Adams.
And Ms. Robinson out, talk to the family for a second and then just on you.
Okay, so is that Ulysses Rogers?
Jalen Hill. Yeah. Wait, no, I announced that they had private counsel.
Yeah, you can't see, and I was like, huh?
My fault. No, because I asked anybody here.
Right,
Jalen
and no one
Hill,
ever
they said
came
yes.
first, like, I mean, so, no one came. Okay, we're gonna bring her to the courthouse, tell her what we'll do, we'll have to bring her back, and this is over, now, let's get the door. Tell her, I said I'm gonna bring her back on the 20th. February, who is this coming?
Sorry, there's actually 3 cases, Candace. Oh, just.
He's got 3 open cases. And then Mr. Montgomery, the judge, when you're busy right there. Okay, let me talk. Right now, they can't even read it, they're not, I've been up, it's rock, talk, they, they're not on. Where they were not going to set up. Take care. You wanna bring him back, you wanna bring him out, let's bring him out, Judge. We're bringing out Mr. Rogers, he wants to, ask for the warrant to be set aside.
He wants to ask Mr. There's a warrant?
I mean, he's in on a bench warrant.
Oh, I didn't know that. I thought it was just a
Yes,
plea and
oh,
arraignment.
yes. Yeah, Ulysses Rogers.
2, 3, and 4.
Positions 2, 3, and 4 on the plea and arraignment.
Okay, I see, okay, all right, he can ask away.
Okay.
That's all I've been doing. I ain't gotten the 3 weeks. And then they had grace now, we said a whole.
I saw it.
song, but we had nothing.
Yeah, oh,
They don't know what it is. They might be in the word all day.
Withdraw if you don't like.
no.
Huh? Okay, I'm just trying to think.
But if I get him negotiated, and then do I still get my chance to reinstate the bond?
Yeah.
I do that then, and then I withdraw it and then reinstate my bond.
You're having, thought you were through those.
No, but I'm down.
Me too. They're horrible.
50.
Yeah,
We got over 60.
no,
Okay. You're a little younger than me.
what might happen? See?
No.
Yeah.
I beat both of you.
Yeah. Who we waiting on now?
Are we waiting on, Mr. Adams, you ready? Mr. Jenkins, Mr. Brown?
Y'all ready?
Yeah.
You're on.
All right. So it's position 2, 3, and 4 for Ulysses Rogers. 23 SC 190738, 22 SC 182210, and 21 SC 79028.
Yeah, can I make an announcement on regarding those, John?
Absolutely.
Yeah, we have a couple of offers from the state. And also we have the option to do a non-negotiated plea with the right to withdraw. And he is here on a warrant, bench warrant, because he missed missed a court date. He wants to see if he could get that reinstated. The reason he missed is had a sister that died on June 2024. And the mother died August 2024. That's the reason he missed the court dates. We'd like to address that issue first and see what the court's thought about reinstating.
So you say someone died in June and someone died in August?
Correct. Is that correct?
Yes, sir. I got proof, and I got proof.
I don't know.
I'm not sure when the court date was.
February.
February? What's that gonna do with it? Missing court?
Yeah, we didn't. My mom, she was.
Oh, you didn't get notice? Okay.
Yeah, my mom, my mom went to the nursing home after my sister was there.
Don't talk so loud.
Mhm.
All right, what's this? Mr. Jenkins, it's you or who?
Judge,
Okay.
First of all, Mr. Adams is a learned, member of the court and, officer of this court here, certainly in Fulton County, so, we'll take his word as it is. However, I don't know, and it's unfortunate, I feel bad for the defendant, losing family members. I don't know specifically which, court dates he missed in connection with positions 2, 3, and 4. But unless the date of burial and funeral were on the dates he missed, I don't believe that is a sufficient excuse for missing court. While I do understand, also, if he did not receive notice, he has the burden of showing and proving that, number one, of informing the court of any changes and such, for which we do not have that information today, Judge. And so I think he is where he should be at this time, Judge, and you certainly will leave the facts and circumstances in your discretion to, I guess, set aside the bench warrant in this case and make a decision. But the state will leave that in your discretion, but we're not going to consent to the set aside motion at this time, oral in nature, Judge.
All right, so I'm sorry for your loss of your mother and your sister, but this looks like you missed it was a February day.
Notice for that.
You haven't proven that you didn't get notice.
That proof I didn't get notice.
Either missed, the order of judicial hold was placed February the 29th, but the plea and arraignment date then was the 25th of January. So, and I don't see where any notice was returned.
Okay.
And then there was you bonded out on the. Okay, 23. I don't see anything where notice was returned, so the burden is on you. But so, and it is just on the one case, position 323 SC 190738. That's the one where the bench warrant was issued, Mr. Jenkins. And the other two are the other two open cases. Am I right, Ms. Woods?
Yes, but we've set aside the bench warrant for him on the 21 SC 179028 case back in June 9th, 2023. So we've been around this circle before with him.
Okay.
And then in the 22 case, we set that bench warrant aside as well. June 9th, 2023.
Okay. Mr. Adams, I don't think I can reinstate at this point. Yeah, and yeah, I don't think I'm going to reinstate at this point.
All right, we'd like to go ahead and do a non-negotiated plea then.
On all of them or just
Yeah,
position?
all of,
On all of them? All right, Mr. Jenkins, you ready?
Yes, Your Honor, I'm gonna, I'll go through the colloquy with the defendant and then I'll have Mr. Brown, read the factual basis.
Okay. You need these, Miss?
And do we have the charging, instruments so I can have at least some basis?
All three of them?
I need all three.
I don't have them.
I think you got, I think he does.
huh?
I know we tried to plea when they come
Did you all sign?
If we tried to plea when they come back to court. If we tried to plea when they come back to court.
Oh, no.
Yeah. Plea copies.
Report, okay.
Can you get 18 months weekend jail? You must say something.
Let me run it back and treat those.
Okay, thank you.
Let me see there.
Probably for a second.
Okay. Okay.
Yeah.
Oh, yeah. I'm gonna go back. That's it.
You're like, whoa, good. We get you one. He wanted to.
You said today you had notice because your name.
Yes, absolutely.
You should tell them.
It was the third class, my girl. Tell you I didn't threaten her. I got proof to show I didn't threaten nobody.
Yeah, I know.
She here on if she's not here right now on the screen, she can come and testify to her mouth.
Okay. It does. I'm sorry, I do. I'll tell you.
Say it again. I can hear you. No, I can't read that.
What?
I can read that.
What?
That's what you said.
Which one?
You said.
This guy.
Can't find him. I can't find him.
I thought you said it's in jail.
Probably been in jail, but I would say it's in jail. I might can't find him.
Huh?
I don't know where he is. I might can't find him. I don't know how to find him.
No, you don't.
I can just look for weekends, but I don't know that is in my family.
That's what it is.
I died here first. I know how you. No, I
You
can't.
calm down. I'm trying, you don't pay attention.
You know, the woman, can she please?
Might knock him off.
Please, please. Hey, can you please, I said, can she please give me 18 weekends? Please. Or time sorry. 18 weekends. I can't understand what you're doing.
I'm trying to get probation. Yeah.
Okay.
How many times have you said that?
Never been on probation for none of those charges.
I know.
Oh, it's the same case, okay. You let me back in there. You got the other one of the same case.
Is the DA gonna go with probation?
Thank you.
Going with this.
He's going with 18 months.
Yeah. President.
11 months. So he's going for 18 months. He's ready for 11 months.
Yeah. And just 7 months.
In county,
Mhm.
and if she do give it to me, can you ask her
And
in county?
I'm gonna ask for all that.
Okay.
Just wait. Let me say what I'm gonna say, then if you got to add something, let me know.
Mm-hmm.
He said he don't want to try to run.
Hmm?
You don't want to find him.
I do want to find him, but I don't know if I can find him or not.
Oh, okay. But you don't think he's in jail?
I don't know. I don't know where he is. He would know the human being. I don't know where he is.
Okay.
Staple remover. Sanders, you got a staple? Oh, we've got one over here.
Okay.
Yeah, there's over here on April's desk. See it right there.
Mhm.
I'll be easy on you. I'll sign my name already.
Okay.
That one. On this one.
Mhm.
This is two. Count two.
Okay.
That's all. All right.
Mhm.
I guess.
He's doing
Well,
it.
me.
Yeah.
Okay, so there you go. So you look through here and find your warrants and you'll find your facts. And that's as to each case.
All right, so I just gotta read out each case and then.
So
Yeah.
he probably should do one so he can show you.
Yeah.
So that's the probable, I don't. Did he tell you which one you
We can
read?
do offer plea, which
Okay.
if you're not
So
admitting you
I'll
did,
tell him.
you think it's in your best
Okay, Ms.
interest.
Robinson, can you
Okay.
come out this
Mhm.
way? Okay, while he's getting that together. Oh, don't worry about it. I mean, I'll tell you about that after.
Okay, no problem. Well, we ain't gonna deal with it.
So you're doing the plea colloquy? Okay, come on, Mr. Brown.
But I'm gonna give.
I got it. I got the facts. He's gonna come with me and Mr. Brown. So, you know, get him.
Older than.
Take your time.
All right. Getting to work.
Yeah.
Ready?
It's offer plea.
Okay, all right, okay.
Thirty-first. Sanders, I'm glad it's Friday.
Yeah.
Robinson is going.
Okay.
Ms. Woods?
You go buy me lunch.
He told you to follow me out to the back.
You know.
Come back here for 2 seconds.
If they give me probation, back 15. I promise to God I do, man. Please, if they give me probation, please. I got down to my son, my job, my house. I'm gonna lose out on everything, I promise. Please, I don't wanna lose out on my life just for this man. You know what I'm saying?
Mhm.
Please.
I was sick. Sick for the pool and then I disappeared for the pool and I got sick up by.
Speak softly. Where was the, okay, the cops came out here.
They didn't even, if I had a traffic ticket, I don't got
No,
no
forget that, okay.
They ain't get no traffic ticket or nothing. Like if I was so if I want a traffic ticket, if I was
Just
driving
tell me what happened.
Remember that?
I didn't, the police just pulled the car over. The driver got the car, started running.
I'm
So,
driving that.
yes, when the driver got the car, started running, he left the car right there. I hopped out of the car, I just walked away, and the officer told me to come in and lock me up. And said I had a gun. I didn't have a gun. They didn't find it on me. They didn't find it close to me or nothing.
Okay.
He was the driver of that car. That's who gun he was.
Where was the gun in the car?
It was outside. They said they found it outside somewhere, but not by me or not by him either.
But you think this guy's, you think he's in jail, right?
Mm-hmm.
Something else?
Something else, yeah.
Fulton County?
I think Fulton County. I guess same. I'm not close to that. You can call my girl right now. She can tell you I didn't threaten her. She really with me. She with me come home. She knew I didn't threaten her. That case was been thrown out years ago.
Yeah.
Actually, you can't the judge to grant the probation to me? You can't the judge to grant the probation to me?
I think so.
But they don't want them 7 more months left, right? So they don't want me to serve 7 months. So that's either can I serve the 7 months weekend jail or can I just do 5-10 years probation?
That's what I'm gonna ask one more else, and you don't, you want to add something, you tell me.
You know, we all crazy. You have to be in this place for so long.
You do prep and I
What's prep?
on how I cut the vegetables, I prep for the next day. I cut vegetables, I prep all food before being cooked.
Okay. They still doing good business?
Huh?
They still doing good business?
Yes, sir. And she said once the boss lady said once I get released, I can come back to work.
Yeah, every time I go, they're pretty full. Yeah. Do a good bar business. They do a good bar business.
Yes, sir.
But you got.
They gave me credit for 11 and a half months.
Well, that's what you said you done, yeah.
Okay, so what does the state give me credit for?
They just, all they say is, one thing, they have to look it up.
I'm thinking you saying they already looked it up and give me credit for 11 months. So what is you telling me then?
Yeah, that's what you gonna get, yeah. They were like 1.5 months.
How do I know what I'm gonna get? You ain't can't talk to the DA about that.
Please let me tell it.
Yeah. So basically, it's gonna get credit for 11 months.
They put 11.5 months.
Oh man. Oh,
Hey, why you do that?
other lawyers don't like that. I don't have a lot of lawyers, man. I don't never did.
You get 11.5
They always
months.
handle business.
You get 11.5 months.
I really take
Huh?
years probation. I really take my probation time, please.
That's what we try for.
Can you all know I'm not on probation and I'm willing to take probation?
You want this?
They all know I'm not on probation and I'm willing to take probation. I'm not on probation anymore.
Well, it's over, you know. You thought it was till April, but we got knocked down in January. That's over. You gonna hurt yourself if you get angry. Be calm.
I'm saying, man, actually, what's the chances of them giving me the probation?
Huh?
What's the chances that I take probation?
Good.
Okay, all right.
If you act right.
I just making sure.
Yeah.
Wait for the state. Everybody ready? Everybody signed up? Yes.
We'll come to order.
We got it? Okay.
And everybody get ready.
And y'all are okay with pleading on doing all three cases?
Yes,
Right.
Judge.
Okay.
Negotiated, at this time, and, we'll see what happens.
Okay.
When everybody's ready. Sir, if you would, please raise your right hand. You swear or affirm the testimony you give this honorable court will be the truth, the whole truth, and nothing but the truth to help you God or affirm.
Yes, sir.
All right, you can lower your right hand. And please state your true, correct legal name for the court reporter, spelling your first and last name.
Ulysses Rogers, ULYSSESROGERS.
Ms. Sanders, can you hear him okay? Oh, okay.
Ulysses Rogers, ROEGERS, ULYSSES.
Thank you, sir. I think if you just talk louder, you don't necessarily have to get right in the microphone.
Yes, ma'am.
Thank you, sir.
And as you stand before this honorable court, are you under the influence, any drugs, alcohol, any medicine that we from understanding what we are doing here today?
No, sir.
All right. And what is your highest level of education?
11th grade.
Right. Do you have any problems reading, writing, understanding the English language in any way?
No, sir.
All right. Standing to your left is Edward Adams. Is that your attorney?
Yes, sir.
And are you satisfied with the services at this time?
Yes, sir.
All right. Do you need any additional time to speak with them before you enter this?
No, sir.
All right. Mr. Adams, do you and your client waive formal reading of the charging instruments in these cases?
We do.
All right. Now, Mr. Rogers, you understand that you're facing three different cases.
Yes, sir.
And indictment number 21 SC 179-028. You are facing one count of misdemeanor obstruction of a law enforcement officer. And one count, count two, possession of firearm by convicted felon. Do you understand that?
Yes, sir.
All right. And indictment number 22 SC 182-210. You're facing one felony count of terroristic threats. Do you understand?
Yes, sir.
And in accusation number 23 SC 190-738, you're facing one charge of possession of methamphetamine with intent to distribute. You understand?
Yes, sir.
All right. Now, it's my understanding that you will be entering a non-negotiated plea here today, here for this honorable court. Essentially, what that means is this, that you will enter your guilty plea. The state will make a recommendation as to your sentence. You, through your attorney, will request a sentence from this court, but ultimately the court will make its decision of what it wants to sentence you to. Do you understand that?
Yes, sir.
I do believe because of the time you have the right to withdraw that guilty plea at this time. You understand that?
Yes, sir.
All right. It is also my understanding that you want to enter these guilty pleas under Alford versus North Carolina. Is that correct?
Yes, sir.
All right. Essentially what that means is that while you may challenge some of the facts and circumstances that you would be in this case, you understand that there's a chance that you may be found guilty. You went to trial. And at this time, it's in your best interest to enter a guilty plea to each one of these charging instruments. Is that right?
Yes, sir.
And did you discuss that with your attorney, Mr. Adams?
Yes, sir.
All right. You still want to move forward here today?
Yes, sir.
All right. Now, in addition to that, I must advise you what type of charges and the minimum and the maximum sentences you could be facing for this. In indictment 21 SC 179-028, it is the state's intention to null cross count one against you, and that is the misdemeanor offense. But you will be entering a guilty plea under Alford versus North Carolina to possession of firearm by convicted felon. And that's charged and carries with them a maximum sentence of up to 10 years and a minimum of 1 year in the state penal institution. You understand that?
Yes, sir.
And I apologize. And a minimum sentence of 1 year as a maximum sentence in the state penal institution. You understand that?
Yes, sir.
That charge can be probated, the charge can be suspended in that case. In indictment number 22 SC 182-210, you are charged with a single count of terroristic threats. That also carries with a potential penalty anywhere from 1 to 10 years as a maximum sentence in the state penal institution here in the state of Georgia. That charge can be probated and suspended as well. You understand?
Yes, sir.
And finally, an accusation number 23 SC 190738, charging you with possession of methamphetamine with intent to distribute. But as a felony, appears with a potential penalty anywhere from 5 to 30 years is the maximum sentence here in the state of Georgia. Do you understand that?
Yes, sir.
All right, now, and so your maximum exposure in all of these cases combined is up to 20 years. Do you understand that?
Yes, sir.
I apologize. That is not correct. Adding all of these cases together, your maximum sentence is up to 50 years. That's 30 years on one case and 10 in both. So that's 50 years of exposure. Do you understand that?
Yes, sir.
All right. That doesn't mean that's the sentence you're gonna get, but that's your total exposure. Do you understand? You
Yes, sir.
understand?
Yes, sir.
Okay, no problem. And knowing that you know that at this point in time. In this case, now you understand by entering the guilty pleas in these matters under Alford versus North Carolina, you'll be waiving certain constitutional rights that you have. Do you understand that?
Yes, sir.
Waiving your right to trial by jury. Do you understand that, sir?
Yes, sir.
In that trial, you're waiving your right to remain silent or your right to testify on your own behalf. Do you understand?
Yes, sir.
You're waiving your right to have the state prove your guilt beyond a reasonable doubt at trial. You understand that?
Sir.
You're waiving your right to subpoena witnesses, offer evidence and testimony on your behalf at trial. You understand?
Yes, sir.
You're waiving your right to confront and cross-examine witnesses presented against you by the state of Georgia. Do you understand that?
Yes, sir.
You're waiving your right to the assistance of your attorney, Mr. Adams, at trial. You understand?
Yes, sir.
If you went to trial, sir, and were convicted on these cases, you'll be waiving your right to appeal your conviction to a higher court in the state of Georgia. Do you understand that?
Yes, sir.
And further, if you are not a United States citizen, Mr. Rogers, by entering a guilty plea in these cases would result in your deportation from this country. Do you understand that?
Yes, sir.
Further, if you want to challenge the voluntariness of this plea in all of these cases, because you're entering guilty pleas to felonies in the matter, you have 4 years from the day's date before file what we know as a habeas corpus motion petition. Do you understand?
Yes, sir.
If you are currently on probation or parole here in the state of Georgia, federally or any state in this country, you understand, by entering a guilty plea to all 3 of these cases would be a violation of terms and conditions of any probation or parole you may happen to be on. You understand that?
Yes, sir.
All right. And knowing that, you still want to move forward with this plea here today.
Yes, sir.
All right.
Just a tad louder for the court report, okay? She's got to be able to hear you.
Yes, sir. Yes, ma'am.
Thank you.
And in accordance with this plea, and your plea of guilt, if you do not withdraw it, the state at this time will be withdrawing its previously filed recidivist notice against you.
Yes, sir.
All right. Now, I'm going to show you the charging instruments in these matters. Mr. Rogers, in indictment number 21 SC 179-028, there appears to be a signature where it says defendant. You recognize that signature?
Yes, sir.
Is that your signature?
Yes, sir.
You sign that freely and voluntarily?
Yes, sir.
All right. And in count 20, I apologize, in indictment number 22 SC 182-210, there appears to be a signature where I'm pointing where it says defendant. Do you recognize that signature?
Yes, sir.
That you sign that freely and voluntarily, sir?
Yes, sir.
All right. And then accusation number 23 SC 190-738. There appears to be the signature where you said, where we see defendant. You recognize that signature?
Yes, sir.
And whose signature is that?
Mine.
All right. And did you sign that freely and voluntarily?
Yes, sir.
In indictment 21 SC 179-028 to the charge in count 2, possession of firearm by convicted felon. Sir, at this time, how do you plead?
Guilty.
In indictment 22 SC 182-210 to the charge of terrorist and threats, how do you plead?
Guilty.
And in accusation number 23 SC 190-738 to the charge of possession of methamphetamine with intent to distribute, at this time, how do you plead?
Guilty.
All right?
I understand they're all under Alfred. Okay.
Yes, that's our understanding that you were entering a guilty plea in all these cases under Alfred versus North Carolina. Is that right?
Yes, sir.
All right. The factual basis, will come up.
As soon as you get
As
the,
soon as Mr. Brown comes in, I want to get him some.
break in, you get to break in Mr. Brown,
Yes.
Mr. Adams.
Okay.
Be gentle, Mr. Adams. Don't let it go back on you the very first time you appeared in court, the way we were treated, but.
Give you a copy of the charging instruments, and after you're finished, you can hand them to the court.
Okay,
All
thank
right,
you.
you may as well start in order, so start with 21, 22, and then 23.
Okay, perfect.
There you go.
Thank you very much. All right. Your Honor, the state would expect that this case was to go to trial, that the evidence would show that for case ending in 028, on June 22nd, 2021, troopers of the Georgia State Patrol attempted to initiate a traffic stop on a 2018 Hyundai Accent being driven by the defendant, Ulysses S. Rogers. Mr. Rogers continued to travel at a high rate of speed, ultimately parking in an apartment complex located at 1785 McClelland Avenue in East Point, Georgia, in Fulton County. Officers observed Mr. Rogers running from the driver's seat of the vehicle into an adjacent wooded area. A brief foot pursuit ensued. During that foot pursuit, Mr. Rogers was observed dropping a handgun and continuing to flee. The handgun was recovered by troopers, and Mr. Rogers was later discovered concealing himself in a creek at the rear of the apartment complex. As it relates to case number ending in 2210, on April 11th, 2020, Mr. Rogers did threaten to commit an act of violence toward the victim, Shamanda Timms, last name Timms, T-I-M-S, first name Shamanda, S-H-A-M-A-N-D-A, by stating, "You are dead," in the presence of two Atlanta police officers. The reason being he was upset because she called 911. As it relates to case ending in 0738, on May 25th, 2023, officers of the Atlanta Police Department conducted surveillance at 215 Forsyth Street in Atlanta in Fulton County, and did observe Mr. Rogers involving and engaging in hand-to-hand drug transactions. Mr. Rogers was stopped and ultimately attempted to flee while placed in handcuffs. Mr. Rogers was located with 24.2 grams of meth and $5,030 in U.S. currency.
Mr. Brown, was that Forsyth Street?
My apologies, Your Honor, mispronounced Forsyth.
Okay.
Also, Mr. Brown, did all the factual basis that you just gave this court, I just think I made a word up, did all happen in Fulton County?
Yes, sir.
All right.
Okay. All right. Mr. Adams?
Yes, Your Honor. He did it, those are the facts of the case as North Carolina office police, so when the state had made an offer, or they made it yet?
Mr. Jenkins, he's right.
I apologize, Your Honor.
Did you make the offer? Oh, okay, you don't have to.
You know what? Hey, that would be important, I wouldn't.
Exactly. He just put the limits. I was like, okay.
That's why I started.
Yeah. I thought he was, I didn't, yeah, I didn't know if he was gonna let Mr. Brown do it.
Your Honor, in all three of the cases that are before this honorable court, the state's recommendation is as follows. For the defendant to serve a 10-year sentence, to serve 18 months in prison, with the balance being probated All cases to run concurrent with one another, so he'll be serving one probation is our intent with the following terms and conditions. That the defendant complete 200 hours of community service, that the defendant forfeit any interest in all evidence seized by Atlanta Police Department in this matter, that he avail himself of drug and alcohol evaluation and screens, that he complete the MRT, I believe that is the moral recognition therapy course through the Department of Community Services, that he have no violent contact with Shamanda, that is spelled SHAMANDA, Tims, TIMS, that he stay away from all incident locations regarding his 3 cases, that he either maintain or show proof of looking for employment while he is on probation, and that he have no further violations of Georgia law or federal law. Thank you, Judge.
Okay.
Credit for time. Then your credit for time, sir, to
Well,
11 months.
he's constitutionally entitled to that. So
Okay.
whatever those numbers are,
Right.
he's entitled to any time he's been on these cases. At that time.
All right, go ahead, Mr. Adams.
So, yes. Yeah, those are the facts that will be brought up in court. I do have affidavits from 2 of the victims, and I have talked to the 3rd one. He's just on case number ending in 2210. That's his girlfriend, I believe. They live together now. Your Honor, he is employed by one of my favorite restaurants. Maybe you know it, La Perilla.
Oh, yeah.
That's it, little Howell Mill.
Yeah.
Been there a while. They go willing to take him back. Did you tell me just had a kid?
Yeah, my son 4.
Oh,
Son 4.
4, okay. Yeah, and he's the only provider right now for his son-in-law. As I stated, the charges are affidavit from others saying we have good defenses, but he'd like to resolve this case. My records show he's done 11 months total for these cases. We'd ask that he be placed on probation for 10 years, or if he require more, that's fine too, but I think it's appropriate that he be able to get out and take care of his family. Alternative, maybe either do daily report center or weekends for the jail time. What we're trying to do is let him out so he can support the family and keep his good job.
All right, anything else?
You wanna say that?
I just want to say, if it's in your will, I just want to get back out to my son and my little sister now. Cause I'm the provider. Cause my mama gone and my other sister gone, so I'm really the provider for my family, for real. And due to the terrorist threat case, supposed to been throughout because Shamanda 10, though we stay together, I got a son with her. That's why I pay my rent at. She came to court numerous times, letting the people know it wasn't no terrorist threat. But I did say you are dead, but you are dead, like I'm not, if you don't tell the police to leave, I'm not fooling with you no more. That's a term of everybody using. Like you were dead, not a threat. Like, and she would come and let you know her life never was in threat. Never. But I'm a real provider for my family, and I'm willing to take the probation or some of you, if it's in your will, to keep me away from our eyes that had to move somewhere else beside from with her. And I just continue with my life with my son. I ain't a violent person, and nowhere near a violent person. I just, if your will, you can just take my probation, or just I could do a week in jail for 7 months, a year, or even the daily report center. I report every day to show you I'm willing to go along with my life the right way.
Anything probation, anything I need to know?
I'm not on.
was an active probation case, docket 14 SC 131510 is still showing on the defendant's booking, and I will submit a warrant dismissal to take it on the defendant's booking.
Okay. How long was that probation for?
It's been
14,
2015,
15?
sentence and probation on this month.
Okay. All right, let's see. Okay, so where's is Miss Timms here?
No, but she working right now
Okay.
because she didn't have a job when I was out. So now since I've been locked up, she had got a job on
hold
Jersey
on.
Mike.
Yeah, so how
I think she's on the line because we gave her the she got the code or she can call right now and she'll click right on.
nobody's on there. You would
She
see
let-
them.
Yeah, she let Judge.
Here's y'all still live at the Abner place? Is that the address where this event occurred? Is that where y'all live still?
No. They won't stay
Okay.
there no more. Won't stay there no more.
All right. I was just trying to make sure, staying away from that.
She all I got for real.
Do you have a position, Mr. Adams, of the state on no further violent contact?
Yeah, that's what.
Because that's who, yeah, and that's who you have the child with?
Yes, sir. Yes,
Okay,
ma'am.
all
Yes,
right,
ma'am.
all right. All right, anything else?
Oh, yeah.
So I'm looking back, there's a lot of failures to appear. The convictions are of a violent nature, your previous convictions,
Yeah, I'm done with that life.
huh?
I've been done with that life since I went
Oh,
to prison.
I mean, I understand, and fantastic. I mean, that's awesome, but I'm just saying, so. And even though you say that's what everybody says is you're dead, well, I don't know a lot of people, and you sure don't say it in front of a cop,
Yeah, I'm
but
sorry. I didn't
you
mean to say
did.
it like that.
So, no further violent contact with Shawanda Timms, stay away from all incident locations, MRT therapy, drug eval and evaluation, forfeit the right to the evidence that was seized, the money, et cetera. 200 hours of community services, all the cases can run concurrent. No drugs, no alcohol, no weapons, no replicas of weapons. So you can't even have a weapon, okay?
Yes, ma'am.
See, did I miss anything else? I don't think there was any other victims, was there? I think that was it. So you've been in 11 months, so 10 years probation, 18 to serve, and 10 on each, so they'll run all concurrent. I'll go with the state's recommendation.
Donna, could you, it's very important that he keep this job and be able to take care of his son. Can he do the weekends? Or just straight probation?
I don't know, I mean, Mr. Jenkins, what does the sheriff allow? I mean, I don't know what their capacity is now at the jail.
Been a long
Yeah.
time since I have, I've done it in the past, but it's been like 10 years ago.
Yeah.
Weekend reporting, that's just, I think, a little bit burdensome.
Yeah.
Their staffing.
Well, their
their
staffing.
staff. So, Judge, in this case, if the court or, I apologize, if Mr. Adams has another request in this matter, give his counsel a little time to talk with his client, we can withdraw the plea. whatever you'd like to do.
I do think, I mean, some places have set up for like work release where you have to sleep at the jail and you go to work and come home, not just on the weekends. I don't know if that's any more doable.
Judge, that wouldn't bother me, but I don't know what.
I don't think they do it anymore.
Huh?
They still do it here. They still do weekends here.
They're not doing work release? No, they're not. They're super shorthanded, even more so than, yeah.
Okay.
Yeah, so unfortunately I can't because they can't accompany that. I mean, I can't do it.
Can you do the straight probation, John? He's not, as you see
Please.
the record, he's,
Hey,
Well, Mr. Adams, but it's criminal history and they were going to recidivize him, although they're taking it off the table. I mean, and a lot of failure to appears and bond, I mean, and probation revocation. So
on one. They can snatch
No, I mean, I at least want to give him that much time to do the right thing, and I do hate that. But Mr. Rogers, I mean, you had the baby and your little sister in 2019,
They have nobody out.
2020, 21, and 23.
If I mess up on probation one time, you can snatch my whole sentence. I gotta come to see you on probation, snatch my whole sentence. If I mess up any bit on probation, snatch my whole sentence, 10 years.
I don't think that I can, I don't think that I could do that. I really
They
don't.
still handle weekend judge here because I asked the sheriff
No,
department.
one, you asked
Not her. When I first came in, they
you
said
asked the.
I was in booking with people who were doing weekend judge. They came on Friday and Saturday and left on Sunday.
Well, some of those get like contempt where they come in on a Friday, they have like 72 hours. So they put a time there to turn themselves in and a time that they're
I
released.
turn myself in, please. I turn
Well,
myself.
no, but they just have to serve 3 days and you let them do it on the weekends. So, only thing I could reduce it down to is 16 months to serve. Now, that's about all I can help you because your record's kind of,
Yes, so what they give me credit for time?
that's just 2 months less. That's all I'll do. Yeah, and whatever time served you have, the number of days, because I don't know for sure what the physical number is, but they'll add it up.
Yeah, if we could do that,
What's the time survey? Okay.
if we could figure out what the time is.
I think only the sheriff can really do it. Let's see,
Everything we went on didn't go. Nothing go.
Your Honor, would it make any difference if we got in touch with the victim on Samantha Timms? Yeah, so the victim on 2210, if I could get in touch with her and let her come in on the Zoom and
well, I
talk.
think the only thing that would change is, I mean, if I would have said no further contact. So you're stating in your place that you've spoken with her and she's fine and and the state said no further violent contact. That's why I made no further violent contact. You know, Mr. Adams, I just told Ms. April, I said, seems like I fill in on these hard days where I got to make a lot of hard decisions on extremely hard cases. My heart hurts when I go home. I know it will tonight, but you know, I do have to look out for the public because you do have possession of methamphetamines with intent to distribute, some cocaine, terroristic threats, willful obstruction of police officers, and possession of firearm by a convicted felon. And you've been charged with that before, so you've had a felony. So there is that possibility that you could reoffend. So all those things that I have to take in consideration. If this was your first offense on these, it'd be a different story, but it's not. No, it's not your first. You've had a criminal history.
Those were all violent robbery, aggravated
Well,
assault.
no, you're not helping yourself by saying that. That's not helping you.
Mayor Pro?
Sure, absolutely.
Now, what, these are affidavits on the two.
The two, which cases?
Put one ending in 0738, 9023.
He's got an additional.
Yeah.
Do it again.
Because I'm gonna withdraw this recidivist notice. Put it back on and withdraw him, so. Take a decision.
Yeah, I mean, so, you know, I don't know if Mr. Stevens and Mr. Johnson know the penalties of it, saying, no, it wasn't his, it was mine. I mean, state can, I mean, that's, you know, I mean, they're admitting to crimes.
Yeah, that's who it was.
I mean, that's what a lot of, typically it's like if a man and a woman get pulled over, the man's like, no, it's mine. Don't, you know, because he don't want his girlfriend to get in trouble. But, you know, I mean, I get that they were that, but
if the defendant is still on active probation, he has a substantial amount of time remaining, the entire balance will be revoked. Simply because he was listed on the APD to repeat offenders list prior to his probation being ending on just by the time expiring.
All right, so kind of what she's saying is she thinks it's probably the best you're gonna get.
So what do you say? I don't know how long I got for critical time.
And that's as low as I'm gonna go. So you can withdraw your plea and take it to trial.
Was somebody looking up, trying to find out
Look at what?
the time?
No, I will not. The Fulton County Sheriff's Department will determine what that time is. Now, I did see where you had served like 188 days, but you have too many cases for me to sit here and go through all the times you've been in and out of the Fulton County Jail in the last 2 years to determine how many days go to which case number. Okay?
Yeah.
So the best person to determine are the people that had you in custody, which is the Fulton County Sheriffs.
I'm gonna come back to court.
I know I saw that one and one for 3 and one for 30, but I can't say that that's it. It's all yeah.
I think know if he's gonna take it, because we have one more case.
Yeah.
For the day.
We got our last case and I've had a very hard day.
I'm gonna enjoy that because I don't know how long they're gonna give me for critical time, sir.
They gonna be
I said, I don't know how long though.
Which one's next, Miss Woods?
on this Hill. The lab. I do.
At least 60.
Jalen is here, is in custody, right?
Oh, yeah.
10 more months.
Yes.
He said that's least, you did 6 months, but you get 4 more.
Mhm.
We'll find the 4 more.
But yeah, I do it here at the jail. Can you
Probably will, it's not up to her.
If you need a second to talk to him, y'all can step off and talk and let's get,
Mr. Adams,
Yeah.
you'll have to wait. Don't wait nothing.
to bring out Jalen Hill.
They gotta bring another inmate.
They gotta bring out another inmate.
This- We're gonna switch gears for a second. Yeah. Good job. This route. Serve at the pleasure of the court. Are you on YouTube? Your fans are.
That's what we did.
I'm reading the comments. They going.
They love them, some April.
So you usually have that many watching you every.
Oh, I don't know how many people watch.
Right now you have, earlier you had like coffee behind you.
As a follow, absolutely. That would be something.
On here,
Behind here, yep. He's on the plea and arraignment calendar. Summerfield.
position 8. Got it. Right here.
Yeah.
All right, so this is 24 SC 006485, Jalen Hill. It was 2 counts of murder, 1 count of aggravated assault with a deadly weapon, 1 count of possession of a firearm during the commission of a felony.
That is correct, Your Honor. Michael Norman on behalf of Mr. Hill. I filed a motion for bond. Mr. Hill was denied bond at his first appearance. Just so the court's aware, Mr. Hill's family is present, including his mother and several other relatives. This case involves a family. The decedent in this case is Mr. Hill's cousin. They were extremely close. Mr. Hill was at his cousin's home when this happened. There was an argument, a shooting, and Righteous Hill, the victim in this case, passed away. Mr. Hill does not have any prior criminal record. He was admitted to college and he was set to start a job, I believe the day after this incident. And the reason I know that is because although I haven't received full discovery, part of discovery I received is the statement, there was a witness present, the victim's girlfriend, who made a statement, which I have, in which she says that they were so close that Righteous had bought Jalen boots and work clothes for the job he was set to start. Now, I will tell the court, because I know that the state is going to bring up, that Mr. Hill was not taken into custody until about 7 months after this incident. Part of that was because he doesn't have any history. He's never been arrested. He freaked out, is the easiest way to say it. And this was someone he was extremely close to, but he did eventually turn himself in. And he wants to deal with this. I think we can, I'm asking for a reasonable bond in this case. I'm asking for a $50,000 bond total with a tether to ensure his appearance, given the delay in him turning himself in. He's been in for 122 days at this point. Again, his family's here. They're very supportive, and they has sat here all day waiting on this hearing. And we're just asking for a reasonable bond so that Mr. Hill and I can prepare for the case and ensure his appearance, which I believe a tether would do in this instance. He's not a threat to anyone else. Again, this was a close family incident, and he has absolutely no record before this, Your Honor.
All right. What says the state?
Your Honor, the state opposes bond in this matter. This is an incident that occurred on February 28th of 2024. The defendant did not, he was not picked up until about 8 months later, Your Honor. But this was a argument between cousins. Mr. Righteous Hill is the victim in the case, and they lived, Mr. Righteous Hill and Terry Wilson lived in East Point together, and Jalen Hill was living with them for about 6 years since COVID, Your Honor. There was an argument because the defendant took Miss Wilson, the victim's girlfriend's vehicle, and had it longer than anticipated. And so there was an argument between the cousins when he returned home. The argument was about the vehicle. And once they began to argue, they were in a room, and the defendant pulled out his pistol. The victim is heard saying, "You're gonna shoot me." And then the argument continues downstairs. The third party in this incident, the girlfriend, Miss Terry Wilson, she indicated that she heard the door chime, so the door opening. And then she heard her boyfriend say again, "So you're gonna shoot me, and you're gonna shoot me." And then she heard gunshots. The victim was shot 6 times in this case, indicating that, and the victim was shot 5 times, but one bullet or projectile was recovered from the door, indicating that he was attempting to close the door as he was being shot. When Miss Wilson came downstairs, she did see her boyfriend lying, shot several times. She called 911. He did make an excited utterance saying that Jalen shot me, and Jalen was nowhere to be found when the police got there or when Miss Wilson got downstairs. He did leave and didn't turn himself in until September 30th of 2024. So that's several months. So the state would contend that he is a risk of fleeing, a danger to the community, and a risk to intimidate witnesses. Particularly, he knows Miss Wilson. Miss Wilson is a witness in this case, and he is likely to intimidate her upon his release, Your Honor. Your Honor, I also was able to speak with the family of the victim, particularly the mother, and excuse me, and she is opposed to bond in this case. And so the state would object to a bond being set in this case, Your Honor.
And just in brief response, Your Honor, they did not live together for 6 years. He was there at the time of the incident, but it was an on and off kind of situation. Mr. Hill has been in the Fulton County Jail for 122 days. He has not made any attempts to contact the witness in this case, although he does know who she is. He hasn't contacted his family and told them to try to contact her. He hasn't done anything to try to intimidate anyone, and he did turn himself in, even though there was a delay, because he had to get his mind together for coming to the Fulton County Jail. And I know that, you know, the court may look at that a certain way, but you can ensure his appearance with a tether. And he will be here, and this is a close family, and the family will continue to be related regardless of how the outcome of this case goes.
How old is he?
23 years old, Your Honor.
And how old was his cousin?
35, Your Honor.
35?
And again, according to the witness's statement, he was a father figure to Mr. Hill. They were extremely close. This is not something that Mr. Hill takes lightly. And I don't want to get into the facts, but there was an altercation occurring when this happened. And Mr. Hill is much larger than Jalen. They're both Mr. Hill. Righteous Hill is about 300 pounds, according to the ME report that I have. And you can see that Mr. Hill is probably 150.
I don't understand these young kids. They're bringing guns, and that's how they resolve all their arguments is with a gun. And not once, but you shot him 5 times. I mean, you don't have a record, but how's he going to pay for an ankle monitor if he's out?
Well, he had just gotten a job. I don't know if that job is still available, but he does have family who supports him, and he will work and through the family support, be able to take care of it.
I think it's like $300 something a month, isn't it?
About that. And I know the county is no longer paying for them.
Yeah, I think if we paid for it, the staff, Ms. Woods probably kill us because she can raise.
Right, yeah.
Let's see. Did you see that? No, on your computer.
Right here. Not guilty. Either however you sign. I know they don't teach cursive anymore. I don't know.
Let me look at the warrants real quick. Oh. All right, let's see. All right, let's see. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. So where does he live right now?
With his mother.
And is that in Fulton County?
Is that Fulton County? DeKalb County.
Mm. So he'd have no reason to come into Fulton County, right?
Not except for court, Your Honor.
Stay out of Fulton County unless court or see your lawyer. So an ankle monitor with a 24-hour curfew. Except for court, lawyer visits. And of course, if he has like a doctor's appointment, he can't, he can obviously run it through. So they indict him on 1 count of murder and 2 ag assaults. Is that right? That
It's
was
1 kind of murder, 1 kind of felony murder, 1 kind of aggravated assault, which I think is the basis for the felony murder, and I mean, and possession of a firearm during the commission of a felony are the 4 charges.
All right. So no further contact with Terry Wilson and no further contact with, what's his mother's name? Mr. Rice's?
One moment, Your Honor.
Vernon Wilcox.
Varner, Varner.
I'm sorry, B or B?
V as in Victor. Last name Wilcox, Wilcox.
All right. So you have to pay for that ankle monitor. So if you can't afford an ankle monitor, you don't charge that ankle monitor, we'll issue a bench warrant for your arrest, period. Okay? All right, so let's see. So 30,000 on possession of a firearm during the commission of a felony. Sorry, Candace. 50,000 for ag assault. And 300,000 on each murder and felony murder. 300,000, 50,000, and 30,000. Best of luck to you, sir.
Thank you, Your Honor.
Is there items ready? Yeah. Oh, we still talked, okay.
Okay, Mr. Adam. Hey, how you doing? I'm not doing anything. I'm not having no time.
No. Gotta get out of here.
I ain't doing every day. I'm tired. I ain't, he really needs to. I feel sorry for his sister and his baby. Cause you do the jail. I really do. I feel so sorry for him. For them, I don't feel sorry for him. I feel sorry for him. Cause he can't control himself.
You stood up and you
He's been
said,
getting
well,
calls forever.
I was like, wait.
What did Mr. Norman go? He went back there? Okay. Yeah, I don't know what's out.
Oh, yeah.
You see, he kind of spazzed out of the.
I'm just thankful for my colleague, Mr. Jenkins, and the grace of the court.
He'll be all right. We're gonna get him straight. Like, best place you gonna be. Trust and believe.
And then we get you straight and tight, what happens is that they'll snatch you up, they'll snatch up and move you after I get you drained. Per usual.
Yeah,
Give me a
yeah,
second. That's what they did, when they moved Christian Act, cause you talking about somebody was crying.
He outside right now.
But I was happy for him. Cause when we came back from, the family division, he actually trained me. Cause I forgot all this stuff.
All right, we're back on, Mr. Adams, you ready?
Let's go, believe you like that.
I appreciate it.
Cause I haven't had breakfast. all
Appreciate it too. They'd be like, what did you do? Yes. Or just picture of some. Think it all.
All right, Mr. Adams, we're back on the record. Go ahead.
Yes, Your Honor, we want to go forward on the 16 months. Credit for time served.
That they'll figure out at the jail.
Mhm.
You know that, right? He's got that.
Right.
Yeah, they'll figure it out. And then the rest of the conditions?
Yes, Your Honor.
All right, Mr. Brown, you good with that?
Sure.
Okay. All right, so they'll go ahead, you'll remain in custody and they'll figure it out and then let you in, and probation officer may need to talk to you before you get, okay?
Yes, ma'am.
All right, best of luck to you, sir. Okay, that's it. That's it. We're good though, right? No more? We can stop?
Yeah.
Absolutely. It's a long day, gosh, draining.